Can I just say something about Andrea?
Well, hey guys, welcome back. Welcome back from our rather abbreviated day in court today. Kind of extra so if you count like the part that's devoted to actually watching evidence and stuff. Oh, we got a lot to talk about today. And we have an early start tomorrow. So, guys, I'm not going to take 5 hours to do it. I am committing right now. You can laugh in the chat. You can laugh. Listen to Andrea saying she's not going to talk for 5 hours. But we got to be sharp for tomorrow because I still have some hope. I still have some hope. But I can't deny it was a bit of a crashing back down to earth day for me. Vis-a-vis Judge Graff. Vis-a-vis Judge Graff, I've been like his biggest cheerleader. I think I've been so strong in his corner. And so, it's hard to be let down like this. I appreciate he's doing his best, but I really think he's missing the point, and I think he allowed himself to get sandbagged by Mr. Novak today. But I still have hope because of this invitation that he gave to file briefs. He didn't specifically invite the media to, but I certainly hope the media decides on its own account that it should maybe weigh in on all this on our behalf. But we're going to talk about all of it. And if you didn't watch the stream today, you may not know what I'm talking about. So we'll get there. We'll get there. We'll take a little meandering trip through our time in court today. Day 3 of the preliminary hearing, just a half day, started at 1 o'clock over there mountain time. And it was nice. It was nice to sleep in because we did have a little bit of a late night last night. So after our standard appearances and advisements and so forth about civility in the courtroom and things like that, Judge Graff went right to what we are all thinking, which is, we scheduled this for a week. We're supposed to end Friday. I gave you guys a lot of time to be able to do this. And so I just want to make sure y'all are being mindful about how much time is left and kind of inviting a little feedback on how are we doing? Are we actually going to get done this week? So what we heard from the state was that they intended to call Brian Davis, the SBI investigator, this afternoon, and potentially then Jen Faumuina, who's already started her testimony, but then we broke so that the defense could get the FBI expert in consistent with her schedule. But those are the only 2 remaining witnesses that they have. So once they are done with that, they're done. They're done. So that is very much a positive in favor of concluding that we are likely to get to the end of this. Didn't quite get through everything we might have hoped for today, but even still, it seems that we are likely on track for the state to finish tomorrow and then the defense to have all day Friday, potentially maybe sometime tomorrow as well if the witnesses are available. For the 2 remaining witnesses they intend to call, who are analysts from ATF. I thought it was 2 FBI and 1 ATF, but it's actually the other way around because the ATF had done the DNA processing on the firearm and the firearm evidence, as well as the tool mark analysis. So that's what I'm expecting. That's what I'm expecting them to testify about. It'll be interested to see with the tool mark witness if Judge Graff has a tighter leash than he did with the DNA expert, because it's almost certainly going to be more of the same. Limitations of the methodology, which are substantial in the case of tool mark evidence, but also pretty beyond the scope of what the court is being asked to do for probable cause purposes. So both parties indicate they think we're going to be able to finish. However, there was early on anticipation of some disagreement, some things that were going to be needed to work out with the court, vis-a-vis a video 1102 that's going to be proffered by the state, and Mr. Novak advised the court they prepared a transcript and proposed redactions because they think that portions of that are inadmissible, and advised the court might want to look at that because it's going to come up today. Now, unfortunately, the court didn't take advantage of it at this time. I guess it doesn't matter because, you know, he needs to pay attention to what's going on in court. But this was a preview. Judge, you're going to need to be reading this transcript in order to rule on some objections. The state agreed that they had received them, and they were just going to be prepared to deal with it when it comes. So they wanted to move forward. In response to the invitation to anybody to take the benefit of the record, I do still love that. Anybody want the benefit of the record? The state, Mr. McBride, wanted the benefit of the record. And what he wanted to do was remind the court of how they intended to proceed with their presentation of evidence, particularly with respect to the use of hearsay to establish the foundation for exhibits, and their intention to continue to do that in open court. The wrinkle is because under the court rules, the decisions the court needs to make for the admission of evidence sometimes require it to make factual findings, and the rules specifically provide that it doesn't have to follow the rules of evidence in order to make findings for that purpose. So that means it's not restricted by hearsay considerations and things like that. It just has to use its judgment and make a reasonable resolution of the issue. And so in this particular case, the judge serves two purposes. He's the gatekeeper of the admissibility of evidence that's being offered, but he's also acting as a fact finder or magistrate because he's making the determination of probable cause, and that's going to be based on his decision about what has been presented here, what's reliable, whether it's sufficient to warrant going to a jury or not. And so he points out that it's the reason why this is a different standard when you're talking about the judge considering the basis, considering, like, you know, hearsay, non-admissible types of things, and how just there's a different framework at play here in this preliminary hearing is because there's no jury. And when you have a judge making decisions, you presume, the courts will presume that judges know what the law is and they will apply it. And so if something is presented in the evidence that isn't admissible, they will know to disregard it. The jury would not. And so that's why more care is taken in a jury process to make sure they're not exposed to anything that they aren't supposed to. But the court doesn't have to do that. It's not so much a consideration. So in this particular situation, Mr. McBride says the state is intending to lay this foundation in open court. And as far as the basic legal issue is concerned, the state and the defense are on the same page. They understand that's what the rules are. That's how all of this works. But the defense is treating this issue as potentially implicating the entire jury pool. And it's just based on language in the rule 104B that talks about decisions being made outside the presence of the jury. And so he's saying that the defense is trying to turn that into not just outside the presence of the jury, but outside the presence of anybody who could potentially be a juror, potentially years before the jury is here to take place. But he does say, hey, he thinks that's fair. We do have to be concerned about not being unduly prejudicial with the publicity and so forth. But he simply advised that there's a presumption the hearings are open to the public. We all know. So they intend to move to admit their exhibits in open court unless someone moves to close the hearing, which they don't intend to do. So clearly, defense, the burden is going to be on you to request a closure and justify it. Mr. Novak responded, this was a funny moment. He's like, just briefly. And we're all like, oh yeah, right. But then he actually did. So it inspired me a little bit. I can do it too. I can be done. I can be done by 10. I swear. He just says they agree. They agree on this issue with the Rule 104 that it's not, doesn't require compliance with the rules of evidence, but he says, because of the Archuleta case, which keeps coming up, keeps saying we're going to look at it. We're not going to look at it yet. We got other stuff to look at tonight. But he says because of that, they're going to object as appropriate, and then the court will make the ruling it makes. So the judge then reminded everybody that we have 3 things going on. Are we admitting it? Are we publishing it in court? And are we publishing it to the cameras? We started off on such a strong foot. He recognized that the angle of the monitor wasn't really good for the camera. And so all the stuff that we've been trying to see, it's not clear. It's like kind of distorted. It's like weird. So he has instructed for the monitor to be kind of, turned a little bit more, and they were going to bring in a second monitor to make sure the camera has a good view of what's being shown on the screen. I'm like, this is going so well. That's maybe the hard part for me, is like how just at ease I was before suddenly, oh, it hits. We're doing that. Oh no. We then of course had to pause for a little tech struggle, which courts and technology go together like oil and water. It's just anti-compatible, pretty much. But we did get our witness called, then SBI agent Brian Davis. Now we have another new prosecutor working for us today, handling this questioning. I didn't catch her first name, and I also didn't get a chance to look it up, but she's Ms. Hunt. And so Ms. Hunt was doing our questioning here. Brian Davis is a 27-year law enforcement officer. He's been 18 years with the SBI. Before that, he was with the Department of Public Safety as a state trooper for about 8 years. And he also spent a year with the Utah Transit Authority Police. He completed his post certification and training in 1999. All of the local, state, any commissioned law enforcement officer in Utah goes through this standard post-training. At the SBI, when he first started there, he was doing covert operations. So he worked on a variety of task forces, investigating violent crimes, firearm crimes, gang violence. He was part of the U.S. Marshals Fugitive Apprehension Team. They go look for people with warrants. An Officer Critical Incident Team. And as part of the Major Crimes Division of the SBI, he's investigated a whole variety of crimes, everything from, the classic major violent crimes to white-collar fraud and things like that. A couple little interesting things that he dropped in. He's on a public corruption task force. No way. You mean you look for, like, cover-ups and stuff like that? You, the state guy, the non-fed, you look for like corruption? Interesting. He's of course had training in homicide investigations. You know what part of that training was? He just dropped it in. Maybe it means nothing, but just happened to mention that he's trained to laser scan crime scenes. All right, guys, 3D laser scanning. This is becoming more and more common as a way to preserve a crime scene, so to speak. This is what they did over in Idaho when they decided they were going to release the King Road house back to the university. Or it wasn't the university at that point, it was a private guy, but then a private guy donated it to the university. The university decided we're going to tear it down. They did a 3D scan of the interior of the house. And what that does is it allows them to just create a digital copy of what it looks like. And so you will have the proportions, the sight lines, all of those types of things will be preserved digitally. So if you're wondering why would you release a crime scene and pave it over? It's because with something like 3D scanning, you can visit the crime scene at any time. And that means that the value of the physical crime scene is largely related to the physical evidence that you can recover from it. Footprints, shell casings, all of those types of things. So once you've done that, and 3 days is more than enough to process a scene like this, then there's nothing else to get from it. And frankly, I think we talked yesterday about, like, the more time that goes on, it's going to deteriorate from environmental exposure anyway. So I thought it was very interesting to mention that, because I wonder if they did a 3D scan of the crime scene. Wouldn't surprise me at all. But it could be nothing, because he also mentioned he's trained as a forensic child interviewer. It's a specific technique that they use for child victims in particular, who are especially susceptible to suggestions. So you have to be very, very careful when you question children that you don't just even inadvertently encourage them to say something because they think that's what you want to hear. He's also currently on the cold case team for SBI. So he was assigned to the homicide of Charlie Kirk. He was the case agent with Agent Hull. As the case agent, he's responsible for the case. That means he manages it, he directs it, he makes the assignments. All the reports and the evidence come to him. He's like the point person for the information. And he's ultimately the one who will screen it out to a prosecutor if he believes it warrants charges being filed. On a large case, it can be typical to have more than one case agent. And so this case is a large one. There were many other police agencies involved, but SBI is the primary. So it's a state case. We got to at least get our lingo right. Okay, if we're going to use thought-terminating cliches, this is not a Fed slop case. The feds are minor players in this. It's a state slop case. It's I mean, Cox slop, you know, it's his I don't know, but it's something. It's not feds, guys. This is not a federal case. This is being run by the state. But they did get assistance from the FBI, the ATF, several local and state agencies, Utah County Sheriff, Washington County Sheriff, UVU Police, Orem Police, lots and lots of different agencies. We know, we've seen the list of 28 that have provided discovery over the course of this case. We moved on from September the 10th and what happened on that day. Prosecutor moves us forward now to the next day, September 11th. So that day he spent at the command post. He testified that about 8:30 in the evening, he got a phone call from, I believe it was Sergeant Eschels. I don't know how to spell it, but that's what it sounded like. Wrote it out phonetically, Sergeant Eschels, from the SBI, requesting that he travel to St. George. And that was because they had received information that an individual had or was about to turn himself in for the shooting. So he went to St. George that day. They flew in from the Salt Lake City Airport, I think. And he flew down there with other SBI and FBI agents, as well as Mr. McBride, a prosecuting attorney, was there for this. They arrived around 11:30 in the evening, went straight to Washington County Sheriff's Office. On the way, they were coordinating with local agents down in southern Utah from the FBI, as well as the SBI agents from Utah and the Washington County Sheriff's Office. So they got to the sheriff's office itself around midnight. When there, they met with several other investigators and prosecutors. There were also federal prosecutors that were present for this. They were told that the individual wanted to turn himself in. He saw that person from the room where they can monitor what's going on in the interview room. And so the TV is on, and he sees somebody on the screen that is sitting in this interview room. Asked when that person arrived at the Washington County Sheriff's Office that evening, he testified 9 p.m. that evening. About 9 p.m. He came accompanied by his parents and a family friend. Agent Davis spoke with the individual to get his name and date of birth. Pause. I talked about this a bit on the live stream, but questions, swirling about the timing of Miranda warnings and things like that. Does this indicate, if he's asking him questions, that he was Mirandized? Not necessarily, because this is basic biographical information, name and date of birth. And so this is typically information that they don't have to give Miranda warnings in order to ask these particular questions. They're not inherently incriminating who you are. So they're generally allowed to do that. The gentleman identified himself as Tyler Robinson. He stated that himself, but then the other individuals that were still present there as well also talked to law enforcement. So Tyler's mom was interviewed, Tyler's dad was interviewed, and Mike Mitchell, the family friend, all of them were interviewed simultaneously. So Agent Davis himself and an FBI agent Folger interviewed Tyler's mother. So they were able to get information, through the course of those conversations. The reason why they're not telling us what they learned from those individuals is because unless they did it in this formal 1102 fashion where it's sworn and under oath, and if you lie, then you could be criminally prosecuted and so forth. If it's not formal like that, then it doesn't meet the requirements for reliable hearsay. They don't have to get sworn statements from other police officers. That's another exception. If they're just getting information from another police officer, they can put that into evidence. But just relating hearsay statements from witnesses, they're not allowed to do that unless it's subject to those 1102 warnings and so forth. So after the interviews, at the time of the interviews, Mr. Robinson was being detained. After the interviews, Mr. Davis testified that he was then formally arrested. What's the difference between those things? On the surface, they look very similar because both of them mean you're not free to leave. The police have you, and you aren't going anywhere. The difference has to do with the scope of what's permitted. Detentions are by definition temporary. And so you're allowed to be temporarily detained by police on reasonable suspicion that you might be involved in criminal activity for a reasonable length of time to investigate and either confirm or dispel those suspicions. If you've gone through your investigation and you can't develop enough information to justify an arrest, then the person has to be released. They don't get to detain you indefinitely. But if they develop then probable cause, a higher standard than the reasonable suspicion, then they can take you into formal custody under arrest, and this is basically now indefinitely until the court gets involved. Well, I shouldn't say that. It's typically 72 hours to file charges, and a probable cause determination has to be made. But then once charges are filed, now we're in the ballpark of the court deciding, are you entitled to release? Do there need to be conditions, and so on and so forth. So that's the difference between detention and arrest. The detention is inherently temporary. and it's either going to give grounds to arrest you or they aren't going to be able to develop it and they have to cut you loose. So these interviews all took place at the Washington County Sheriff's Office on September the 12th, early morning hours. The arrest was formalized at about 4 o'clock in the morning. And so then we turn to State's Exhibit 15. Asked if he observed Tyler Robinson at the Washington County Sheriff's Office. Yes, he did. And he reviewed interview room video. So this is the it's like almost always in the ceiling. They have in-ceiling cameras in the interrogation rooms. They're mic'd up. So there's sound, there's visual. And that's what Exhibit 15 was. They had previously agreed, the parties had to redact some portions of the video. But with that, then there was also an agreement that it could be published. So no argument over that. Seems like there's at least efforts to try to coordinate some of this stuff. I don't think they're gonna actually come together on a lot of it, but on this occasion they were able to. So we did see a brief snippet of video of Mr. Robinson in his shirt, his hat, it's the red shirt, the blue jeans, the black and gray Converse, the black hat, walking into the room, and then he turns his back. He's like looking back at the door, and we see his back facing the camera for a few minutes, and that's it. The video isn't time-stamped, so we don't see visually on the screen what time was it, you know, when he's walking into this room. But we would expect if he turned himself in to the Washington County Sheriff's Office at 9 o'clock, that this would be in that ballpark. Not like, it doesn't, you know, sometimes you wait at the desk, they're standing around. It's like any public office. Takes a minute to find the person with the key to get you back there and yada yada, because you always have to go through locked doors, you know, to get into the back part of the police department. But, you know, 9:15, maybe 9:30 on the outside is what I would expect that timestamp to be. Prior to their arriving at the Washington County Sheriff's Office, meaning the investigators arriving at the Washington County Sheriff's Office, his cell phone had already been taken from him. So sometime between him surrendering at roughly 9 o'clock and the investigators arriving at about midnight, they had taken his phone away. So he didn't have access to his phone, but the Discord chats under this timeline took place an hour and a half before he showed up at the police department, at the sheriff's office. So there is no timeline issue according to this testimony. After he was arrested in the early morning hours of the September the 12th, he was transported to the Utah County Jail. Then after he was transferred as well, they started processes to get search warrants. The local police did. They collected his clothing. They collected, they keep calling it a buccal swab. Maybe they're right. Maybe they're right. I don't know. I'm not going to argue with, you know, certainly not like the DNA people who actually do this. I just really heard it buccal. I could be wrong. I could definitely be wrong. It's going to take me some adjustment to get used to buccal swab. But I do want to kind of be consistent if it's not like obvious that they're wrong and they're just, you know, I want to be consistent so there's not confusion about what we're talking about. And I can't say they're wrong. I don't know that. It's just I've heard it pronounced differently. And then also prints, a full set of prints, fingers, palm, collected all of that from Tyler. So he arrived in Utah County at about 7 o'clock in the morning. He was booked in at about 8 o'clock in the morning. So guys, if you're wondering why did they wait to talk to him, to interrogate him, we have that Miranda advisement in the transcript with the 625. Now, it's very possible he was Mirandized multiple times. That's not uncommon. But I don't think he was Mirandized before any of these officers arrived, just based on the statement that we got from the press release of the Washington County Sheriff. He told us that, repeatedly insisted we were not part of the investigation. We were an agency assist, so we did not do any interviews. We didn't do any interviews. So unlikely they Mirandized him if they weren't going to talk to him. But as far as the other folks, it's not that unusual to be Mirandized multiple times. But I'll say they didn't. First one is at 6:25 p.m. the next day. Does that seem weird? Does that seem like a really long time? Guys, he went all night without sleeping. I mean, maybe he got a few winks in the car on the drive, but I'd kind of be surprised. Like, how well are you going to sleep after you've surrendered yourself on a high-profile homicide that has just captured the attention of the entire country? Like, literally everybody has been looking for you, and the pictures are out and all that stuff. I kind of think he probably didn't get very many winks on that road trip. So he went all night without sleep. You're gonna let him recover. You're gonna let him recover. You don't want a situation where he's like strung out and sleep deprived, because it starts to look more like a coercive situation. These are like one of the factors that are going to come into whether, if he had chosen to speak, it's voluntary. There's not any one real dispositive fact that will make an interview, a statement, voluntary or involuntary. It's always a totality of the circumstances. But things like, look, I had been sleep deprived for many hours, didn't sleep all night, and then they come in and I was exhausted, and can't see right. And they knew all this, by the way, because they knew I turned myself in at 9 o'clock, and they knew I'd been sitting there, and they got there at midnight and drove me back. So they knew all this, and they took advantage of it. It gives them a free argument. So just let him get his sleep, let him get his rest, let him go through his first appearance over there at the court, and then talk to him. It's clean. It's clean. So the timing of all of this does, I think, add to reasons to suspect that 625 Miranda rights took place on September the 12th. Agent Davis was the booking officer, which means he got the privilege of doing all the paperwork. And so that's why we see the paperwork that he filled out has the arrest indicated at 4 o'clock, because that's what he indicated. That's when we went through the formal arrest there in Utah County. But then he wasn't formally booked into the Utah County Jail until 8 o'clock in the next morning. But both of those, of course, being on September the 12th, after the clock had turned over past midnight to the next day. They did get search warrants pretty quickly down in southern Utah for Tyler's house, as well as for his parents' house. Both of them were searched on the 12th. Sergeant, now I forgot how to pronounce her name. Fumuina. She was the one who searched Tyler Robinson's house at about 8 o'clock. So we'll probably hear more about that when she gets back on the stand. And then the FBI evidence response team searched Tyler's parents' house later that afternoon about 4. At the time, Tyler was living with Lance Twiggs, and they had gotten some information. We paused to talk about Mike Mitchell, the family friend who had accompanied them into the Washington County Sheriff's Office. So he had facilitated the surrender with the sheriff's office, just identified as a close family friend. So law enforcement interviewed him. We already kind of heard about in the early morning hours of September the 12th. That was by SBI agent Terry and an FBI agent Smith. They then got a second statement from Mr. Mitchell on March 31st of this year. Present for that were Ryan McBride, Mr. Grunander, Another Utah County Attorney, Kim Overfleur, I think her name was, and then SBI agent Chris Terry. So they all got Mike Mitchell's statement, met at the St. George courthouse. And so the process was they just discussed generally, here's what the process is. He was given the form, their standard form to do the 1102. He went into a separate office and took about an hour to handwrite his statement, brought it out, and gave it to them. So we identified the 1102 and identified the warning on it. It'll be punishable by a misdemeanor if there's a false statement. And he testified that that particular warning was also discussed with Mr. Mitchell by Mr. McBride. Nobody reported, nobody helped him with the statement. He did it on his own. So the statement is admitted, 1102. However, the prosecution didn't want to publish this one, either to the gallery there in the courtroom or to the camera. And if they're not going to ask to publish it, then our right to see what's going on is not really implicated because they're not trying to show us. They're just giving it to the judge. So we did not get to see Mike Mitchell's written 1102 statement. It's a little disappointing to me because, yes, it would have described the circumstances around how did you find out that Tyler Robinson wanted to turn himself in? How did this facilitation take place? What happened as far as, you know, just the sequence of events to actually get him there? It's going to be in that statement, but we don't have it. We don't get to see it. Only the judge does at this time. We then took a little bit of a left turn to revisit the bullet that was found on the roof. Remember, there was a different bullet that got found on the roof of another building, not the Losi Center. And so we turned to that, and whether he knows what's that about. Yeah, he knows what that's about. So the bullet had been found on top of the computer science building roof on the far east side. He reviewed the report of the agent who had found it, who was a Ed Schneider, I think, from the SBI. In terms of our layout of the campus, the computer science building is directly southeast from the Losi Center. And then as far as the amphitheater where the event took place, he described it as being east of that and perhaps a little bit south. There was no line of sight to the tent that Charlie Kirk was in from that tent. Also, the caliber of the bullet was 223. So not consistent with what we know from the ATF report. They claim the bullet fragments recovered from Charlie 30 caliber class. It was also a live round. It wasn't a fired, meaning primer hadn't been dented. The projectile is still there. It's still all in one piece. We then moved on to Lance Twiggs. Lance Twiggs, identified as Tyler's roommate. He was interviewed 2 times. First, early on the morning of September the 12th at the St. George Police Department. That was conducted by FBI agent Larson and an agent Lang. He also provided a buccal swab. Officer couldn't remember if it happened at that time or if that happened later when they were searching the house. Getting a sense of the timeline, they spoke with Lance at the St. George PD in the early morning hours, meaning probably before 8 o'clock, then when they went to the house. So he didn't remember exactly when they got the swab, but it happened in one of those places. Just made me question if the swab was voluntary. I don't know. If it was part of the search of the residence, might be consistent with they got a warrant for that too. If he got it during the interview at St. George PD, then it was clearly voluntary, but we don't really know. As far as the phone, he voluntarily provided it to the agents on September the 12th, and it was taken from him, then secured during the interview. So that, we're told, was voluntary. Tends to suggest if he's handed over his phone, probably willing to hand over his DNA too. Don't know for sure, though. The second interview with Lance was on April 20th of this year at the Utah County Attorney's Office. Present were Mr. Twiggs and his attorney, Jill Cottrell. U.S. attorneys, didn't catch their names, but a couple U.S. attorneys, Mr. McBride, Lieutenant Eschels, the same one, Eschels, and then Agent Davis. Both of the interviews with Lance were recorded. So they were recorded. They are available for impeachment, if nothing else, when Lance is called to testify as a witness in this case. Then those interviews will be available to impeach him in the event there are inconsistencies in his testimony. He was given use immunity. We got a not real good description of what that is, but you know what, it wasn't awful. And basically he described it the way I would describe the queen for a day deal, which is kind of how the feds do a lot of stuff with their proffers. It's limited to the time frame of that statement, but that statement within that time, anything that you say, they cannot use that to prosecute you, but that does not preclude the prosecution from charging you based on other evidence that they might develop. So it's not a total immunity. It's just whatever you say cannot be used against you. We are giving up the right to do that. They didn't specify if there is derivative use immunity. There often is, and that's typical in the federal context. When they're doing a proffer, you get both use immunity and derivative use immunity. What that means is it's a little bit of a limitation on charging you based on independent evidence. It has to truly be independent. If they only develop this evidence because of what you told them, it's derived from your statement. So that's derivative use immunity as well. They didn't specify. Don't know one way or the other if they have that. I would expect that's included just because that's pretty normal. So both the Utah County attorney and the U.S. attorneys agreed to the immunity, which was going to be essential really in this case, because nobody knew if federal charges are being contemplated or on the table. And it doesn't help you a whole lot if the state's willing to give you immunity and so you spill your guts, but the federal prosecutors aren't on board. They haven't promised you anything. Then they don't owe you immunity. The state prosecutor can't bind the federal government. So both of them were on board for it. That was probably going to be necessary for immunity to work at all. The 1102 admonition about false statements can be grounds to criminally prosecute you was given to him in the second interview. He's indicated he understood and that the interview was in lieu of him having to come testify live at the preliminary hearing. He didn't want to do that. I think that's pretty clear. He didn't want to be here. He probably didn't want to be at the 420 interview either. But was in his interest probably to do that, particularly given the immunity agreement. So those were going to be his options. Come testify, or come do the interview subject to the 1102 and get immunity for it, or be subpoenaed to have to come down to the preliminary hearing, and then you can either testify without immunity or you can invoke the fifth. You can plead the fifth. Up to you. Up to you how you want to do it. He chose the immunity. He chose the immunity. If he wasn't involved, that's probably the smart call. It's probably the smart call. Most immunity agreements are conditioned on the information you give us being truthful. If you lie, that's a breach of the agreement and they're no longer bound by it. So if you can speak honestly to the police and get immunity, probably going to be a helpful situation. Go to court, No guarantee. You got a fifth, but not necessarily going to make them real friendly to you. Even though, of course, they're not allowed to, formally hold that against you in the court process. The cops are going to be like, oh, why are you, but what are you hiding? What are you hiding? So, seems like the smart move. So at this point, Mr. McBride, Ms. Hunt was aware that the defense has objections to where we are going now. So that should be addressed. And this is now we're turning to Lance's 1102 statement. So Ms. Hunt tells us the defense wants some redactions. She has some procedural objections that if the court agrees with her, it would moot their substantive objections. But so she wants to deal with that first. What she says is that the defense created a transcript, and it's the same thing that Mr. Novak offered to the court earlier that he had described at the beginning of the session. On April the 28th, 2026, the Utah County Attorney's Office provided the video recording of the 1102 to the defense, so they have been aware of it. They've referenced it in their briefs and so forth. It was Monday, she says, that the defense sent us the transcript that they prepared, and it included significant redactions, including about 11 pages of a 21-page transcript. Remember that, 11 pages of a 21-page transcript. It's actually, this is a little over half. A little over half of the whole transcript has been redacted. So her procedural objection is this is sandbagging, basically. She says this is a surprise. We're already, a day into the preliminary hearing when they're giving this to me. They had this since April. It's 3 months later, two and a half months later, end of April, right? Let's just go ahead and call it beginning of May. At least 2 months they've had it. So didn't get to this till Monday. So it's a surprise. They had it's already, now it's disrupting the process because we have to deal with it because they're not handling it in a timely fashion. So she says the state's intention has been to offer the video into evidence, and which consists of both an audio and a visual component. And so she's concerned, of course, because you can't redact a video nearly as easy as you can redact a transcript, and they don't want to just put in a transcript, redacted or not, as their evidence. So she also says that the remedy that they're asking for to redact all this is disproportionate, and that if any part of it isn't admissible, then the court can just disregard that. She cited a whole bunch of cases kind of along these lines about, judges aren't subject to the same concerns about prejudices and sympathies and things like that as a jury are. So if there's stuff in this that's inflammatory or prejudicial or whatever, it's presumed the court knows how to handle that appropriately. Little bit of this legal fiction that we have, it's an old one. This is an old presumption, that judges, by virtue of their wisdom and experience, are just not going to fly off the handle the way that a poor lay person finding themselves on the jury with no experience might do. Of course, we are all human. We are all biased. We are all able to be manipulated some way or another. Nobody's immune from all of that. But, like I said, old rules. So Exhibit 16 is the video recorded 1102. The state now offers it, and they request to publish it. However, the state is agreeing that the media shouldn't get to copy, handle, replicate the exhibits from this hearing, and apparently there are exhibits from the hearing shown to Lance in the course of this video, so they would then be available on the video screen, and then somebody would be able to screenshot it and crop it and rotate it and enhance it and all that stuff, and then we might as well just have a copy, right? So because of that, she doesn't want the video portion to be captured by the camera, but they want the audio, at least, to be available to the public. The judge first wanted to clarify if there was any part of the 1102 statement that occurred before he received the 1102 warning, because that would not be reliable hearsay under the definition. And she said not that they are presenting. So there were definitely some statements. There's always going to likely be some preliminaries. Mr. Twiggs, my name is Mr. McBride. I'm a prosecuting attorney with the Utah County. Here is so-and-so. Do you know why we're here today? Things like that. So there's always going to be some preliminaries before you get to the 1102, but probably not anything substantive. They're not presenting it, but of course, we don't know. And unless and until we see that video, we probably never will know. So we turned to Mr. Novak, who wanted to address these procedural issues first, which is great because that's all that's before the court right now. She specifically said, deal with the procedure first, then we'll deal with the substance. So the procedural issues first. He's like, many weeks ago, the state lodged its anticipated exhibits, and the court had said, I'm not going to review these. I'm going to return them to the parties. And so they understood that to mean that the moment to make objections to the exhibit is when the court is offering it. I'm a Mr. Novak fan, as you know, but I found him a bit disingenuous today. I did. I think this is disingenuous because we already know they filed a motion in limine. Motion in limine are, pre-trial or pre-hearing motions that are meant to deal with the admissibility of evidence. So it's not like they thought that was off limits. They did it. Nevertheless, the court doesn't want to pre-deal with objections. They want to deal with it when it's entertained. He says, we gave the state, it's only a 20 page transcript. It's only that. That's all. They gave the state that. State's never said it's inaccurate. And so there's no surprise here. They had all Monday. They had all Monday and yesterday. They had all Monday and yesterday. Like normally with motions, you get at least like 5 days, to respond. This is such a sandbag. This is such a sandbag. It really is. They had all day Monday. This morning. This morning when? They were here at 9 o'clock for court. But the state had told them yesterday morning that they didn't agree to the redactions. The state had told the defense. So according to Mr. Novak, we're just doing what the court said. When the state offered the exhibits, we were told, objections should be made when it's offered. And now some blame shifting, now some finger pointing. If the prosecutor had just said, well, in light of Archuleta, the court won't consider the inadmissible stuff and we won't publish any of it, we won't broadcast it, then we wouldn't have an issue. We wouldn't have an issue. If the prosecution was willing to be held hostage to our perspective of what the public should get to see or not see, we wouldn't even have a problem here, Judge. You see how crazy this kind of sounds? I like Mr. Novak, but I'm like, whoa, dude. Do you hear yourself? So he says it becomes a problem with the broadcasting because, the variety of categories objections that they have to the video. So then we get into the substance of what the defense's objections actually are. So first off, he says, he says, I'm not trying to be rude here or anything. I forget exactly how he put it, but this is the McBride 1102. It's the McBride 1102. It's him testifying, and then Lance is just agreeing with what he says or doesn't say. Wouldn't be allowed to do questioning like that in a courtroom of a direct witness. It would be leading. And so he's like, I don't, it's not every single statement, but it's the vast majority. Says Mr. McBride also testifies to what 2 other exhibits say, exhibits that he is anticipating the state is going to be offering in this process. described as text messages and a group chat. He describes it, and then the chat says this as like kind of how Mr. McBride is doing the questioning. And he objects on this because it violates the best evidence rule to testify about the contents of a document rather than just looking at the document itself, if you have that available. We're again kind of in a little bit of that circular loop. Those aren't in evidence because we need Lance to authenticate them. That's going to be part of what this questioning is Lance authenticating. Yeah, you got these off my phone. I gave them to you, or whatever. And these are conversations I had with Tyler. Here's how I knew it was actually Tyler on the other end of the line. Those are basic things you have to do for phone communications, for that type of authentication. Same thing with the group chat. That's his username. I recognize it. I've chatted with him a lot. I know what his voice is when he talks online, in this username, in this group chat. This is all consistent. I believe it was him. That's what you got to do to authenticate text communications like this. So we need Lance to authenticate it to get it in, but apparently we need to get it in to be able to talk about it. And it's like, got a little bit of a no way to get into this loop problem. He also objects that there are portions of the 1102 that aren't relevant and that implicate Lance's privacy rights, especially considering the potential if this is going to be broadcast. So he says if the court did order the broadcast of portions of all of this anyway, he says we're not trying to force them to make Exhibit 16 the transcript. They're just using the transcript as a tool to communicate what their objections are, and so the court can see the statements. But he says it's possible to edit the video. You can just cut it. He says we've been told you could do it right here in the courthouse. Take a couple of hours at the most. You want to edit the state's exhibit. But he says, the state wants to shortcut the substantive objections to this exhibit by focusing on procedure. He says, but that's because the exhibit contains significant, not admissible evidence, stuff that wouldn't be able to come in court. So he says if the court just went with Archuleta, just seal it off and don't publish it and nobody gets to see it except the judge, and then we have no problem. Well, yeah, no shit. That's because that's a very extreme position. The court just went along with our extreme position. Then that's our pathway to efficient resolution of this request. Got it, Judge? Give me what I want, and all this will go very smoothly. It'll be a good use of our time. You don't have to waste time doing all this. Just give me what I want, and it'll all be over, and we can move on. Holding the clock hostage. Obviously, that's not explicitly what he said, but it's sure there in the subtext, isn't it? Just do Archuleta and this would all be more efficient. Just shut it all down. Shut it all down. Give us through the back door what we weren't able to get right up front with our motion to exclude the cameras and our opposition to the electronic media coverage for this hearing. Both of those were denied. Just give it to us through the back door, because it'll be a lot easier for everybody. Just give me what we want. So the judge first wants to clarify that nobody is precluded from filing a motion in limine on anticipated issues that are likely to come up. And that's kind of helpful because it puts everybody on notice and they can deal with this stuff ahead of time. But he wants to know very specifically what the objections are. Be specific. He needs to if he's going to need to rule on it, he needs to know specifically what your problem is and what your reasoning is. So we went through it generally kind of over again, not really line by line, page by page, but just categories. So the categories he identified: parts that are not statements of Lance. It's Mr. McBride testifying. This seems to be an objection to the question being leading. Also the hearsay, the basic hearsay, problem that they have. There may be other hearsay in it as well. If Lance is talking about what other people told him, things like that, then that's going to be another level of hearsay in this to deal with. The best evidence rule, already talked about that. Just get the document itself instead of having testimony about the document. Portions that are not relevant, he believes not relevant to the proceeding, and then also admissible under 403. Getting the sense this is talking about Lance and the issues with gender, sexuality, whatever it is. Lance's kind of personal stuff. Not really, he thinks not really relevant to the process. I'm a little on the fence with that. I think it probably is relevant to the extent that it all relates to this motive, this motive and the targeting enhancement that we had to deal with yesterday. State's theory, Charlie Kirk has a religious and political based viewpoint about certain traditional Orthodox, he calls it Orthodox Christian values. To me, when I think of Orthodox, I'm thinking of like the Greek Orthodox, I'm like, I don't think it's that. Or even like the Russian Orthodox, very the Eastern Church. That's what I think of when they say Orthodox. So I think he means mainstream, like mainstream Christian perspectives on sexuality, gender, ideology, so forth, express those politically. Nature of those positions put him on the opposite side of Tyler, and that is why Tyler chose to, do what he did. That's the state's theory. So yeah, Lance's issues, if that's what it is, do seem relevant to that. That's the other side of this coin that establishes you're on one side, I'm on the other side, hence the targeting. So I don't agree that it's not relevant, but the inadmissibility under 403, this is the, it's the prejudicial, the probative value is substantially outweighed by its prejudice. And so that's really what I think they're arguing. Okay, it's like maybe even if it's a little bit relevant, blaring this guy's private stuff out to the world, kind of prejudicial, kind of puts a target on him, that kind of stuff. And again, the court can manage all these problems by just deciding, certain things won't be shown to the public. Just don't give them to the public and there's no problem. It's really all you got to do. Then, vis-a-vis the in limine, the ability to file motions in limine, he's like, well, if the court had said you wanted to hear objections before the hearing, we would have done that, and I guess we'll do that in the future. Judge didn't like this. And I really don't blame him. This is really responsibility shifting because, yeah, you are the attorney. You're the advocate. It's your job to present your case. And if you're going to tiptoe around, I don't know if I should do this because the judge might not like it. You're like, no, I'm sorry. That's not who Mr. Novak is. You're not a very good lawyer if you're going to not file stuff that you think it's a good idea to file. And the judge hasn't told you specifically, don't do that. You think it needs to be done. It's appropriate to be done. You're going to file it. You're not going to be like, well, I don't know. The judge didn't say. A lot of what you do as a defense lawyer is going to piss off the judge, period. You need real thick skin about that. He's been doing it for decades. He's been pissing off judges since 1992. Okay. I don't buy this passive deference show that he's putting on. I don't think the judge liked it either because he says, I'm not here to tell you what to do. I'm not here to interfere with the duties of either party. I'm not on anybody's team. I am not team prosecution. I am not team defense. If you guys are trying to do something that violates the law, I'm going to weigh in. But me telling you how to do your job would be me getting out of my lane. That would be me not being the judge. You guys are all highly experienced attorneys. Everybody here mentioned it even when he was responding. He gives this kind of gives Mr. Novak his flowers. You know, when I signed your pro hac vicia, I think I even said, you know, I was just what extensive experience you have. Very impressive. It is 800 and some cases in Pacer, and like significant percentage of those are death penalty cases. Crazy amount of experience. He knows so much more about how to litigate a death penalty case than the judge does, and he knows it. Everybody knows it. The judge certainly knows it. You guys are highly experienced attorneys. I am not going to get in the business of telling you how to do your job, what you think is in the best interest of your clients. It's literally what you are getting paid the not so big bucks to do. They're getting $223 an hour, the defense attorneys, which is the CJA rate in federal court for capital defense. CJA is the Criminal Justice Act attorneys. That's when they have to hire somebody outside of the federal public defender's office, usually because there's a conflict or because they, you know, case management, too many cases and things like that. So they contract with private attorneys to take these cases on, pay them a fixed rate. For capital, it's $223. That's what these attorneys are getting paid. Guarantee you it is like significantly less than the rate that gets charged for pretty much any other type of work in any part of the country. 223 is a low rate. You guys over in New York and Massachusetts watching some of those cases, you're like, wow, yeah, that sounds so cheap. So then we heard again from Ms. Hunt. As far as there being no surprise, oh yeah, he sent it Monday about 4 in the afternoon. And not like they had all day Monday. They had yesterday. They had like Monday night and yesterday. She says it wasn't accompanied by any specific objections that he had. It's just a redacted transcript. So they got to look at the redactions and they got to guess. They got to guess what problem the defense has with it. So to the extent this was like an effort to kind of cooperate, do this, you know, you're amongst yourselves and not have to bring it to the attention of the court, perhaps this will be a learning experience for everybody, a teaching moment that maybe being a little bit more explicit, maybe doing this a little more ahead of time, anything like that might be good. Or maybe just this isn't going to work, really. I mean, I wouldn't really blame the state at this point if they're, yeah, kind of super annoyed. They're never going to be like, oh no, we won't cooperate with you. At least I hope not, because sometimes prosecutors are that petty, right? Nick McClelland wouldn't take the calls. Or was it the judge? I think it was Nick too. Wasn't it both of them, the judge and Nick McClelland? They wouldn't take the calls from the defense lawyers anymore. You have to put it in writing. You have to put it in writing. You have to email me. Put it in writing. There are some very petty prosecutors like that. But I don't see Mr. Grunander being like that. That guy? Nah, I don't think so. He's like mini Judge Graff as far as his patience goes, at least from what we've seen so far. So they're having to guess at like what the defense's problem is with all this stuff anyway. She says we would need to, to argue the substantive objections. She says we would need to talk about the substance of what is in this thing, which is going to that whole problem with the, foundation. You do it in open court, but it doesn't have to follow the rules of evidence. And so that's kind of where we're getting to now. So if we need to close the hearing, then we need to have that conversation, and the media may want to weigh in on that. Yeah, I suspect they might. Mr. Novak, well, I object. I object to her inviting the media to comment on what the court wants to do. Dude, they have a right. They have a right. The First Amendment standard for closing a hearing, very clear. Hearing's got to be public. Public has an opportunity to be heard on whether the hearing should be closed. They have a right to say. And then he he's suggesting that, well, we did sidebar. We did sidebar. That would be private. Those aren't for public. Sidebars aren't for public, either now or after the fact. So maybe we just do a sidebar. But if we do that, then the transcript would, need to be at least temporarily sealed. You couldn't be more wrong. You couldn't be more wrong. Of course, sidebars are public. How many sidebars have we seen now? How many sidebars have we seen now? We've seen like all the sidebars. It's like one of the first things we go looking for. You watch the trial, and then you get the transcript after the fact. That's the first thing you do. Like, we're going to go see all the stuff that they were talking about that we didn't get to see. All the little behind the scenes, the outtakes. Sidebars are always public. They're making legal arguments, making decisions that affect the conduct of the case. Those are appealable. It's part of the appeal record. It will be transcribed for the Court of Appeals. Like, I'm trying to wrap my head around, how do you get to sidebars aren't going to be public? He's done appeals post-conviction for decades. He's read a lot of transcripts. He knows the sidebars are in there. I'm just, what is this? Where are we? Disingenuous today. I'm feeling like a little betrayed. My idols are really letting me down today. Didn't expect this from you, Mr. Novak. I got a new perspective on your game here. New perspective on your game. There's a little knife ready to go in the back behind that very calm, polite, deferential presentation. I see it now. And I don't think I'm going to be able to unsee it. As long as Mr. Burt doesn't let me down, we're still good. So then we had a new media lawyer today, Mr. Judd. He popped right up and came forward. Mr. Judd says the request to close the court proceeding, that's not a sidebar. That's not a sidebar. It's very clear. Court's got to have a hearing on closure that is open to the public. That is the case both constitutionally. It's also part of the Utah rules. He says you might have to close parts of it, but the conversation about whether it's closed or not, that has to happen in public. He says the court knows our position on it. Everybody knows, thinks these video interviews are really important evidence. They're really important parts of the case. Likely to be a significant part of the court's decision on probable cause. And so that's the double-edged sword. The defense is like, well, that's why you don't get to see it. That's why you don't get to see it. It's too important. It's going to have too big of an effect. It's too significant. And the media is pointing out that's exactly why we need to see it. If the whole reason for courtroom transparency is that we get to know what the judge is basing his decisions on, then it's the most important stuff that we have the greatest interest in seeing. So it's the other way around. This is likely the pillar on which the case is going to be based. That cuts in favor of access. He says Archuleta is also based on stuff other than just, are we putting it on a screen in that particular case? It is a little bit of an older case, right? The 80s. So this is well before live streaming, court TV, all that. There was, occasional televising of trials and stuff like that, but it was usually going to be local. It's like local networks show up and do it. This whole thing where it's out on the internet for millions of people, very new. But anyway, other issues that were implicated in Archuleta, why they were like, the court gets to manage access to the exhibits, is because the media was asking to handle it, to be able to like physically touch it and stuff. And so that creates a whole other set of risks beyond just being able to see it. You might contaminate it, you might break it, you might destroy it, things like that. So he says, the media, of course, thinks that it should all be shown on the screen. It should be shown to the public. Best alternative, at least, let the audio play the way that the state is requesting. And he reiterates, of course, everybody knows the interest in a fair trial is the countervailing interest. That's the weighing against the First Amendment right of access. But the court has already consistently and properly recognized that the mechanisms in place to remedy that, to rectify it, is in jury selection. And he's absolutely right. Squarely what the case law says. We'll be looking at that. So, Mr. Novak, then again, not sure why this should be different than Archuleta. Just do Archuleta. He keeps waving Archuleta. And, he wants to be able to make his closure argument at sidebar, as, it'd be self-defeating to argue it in open court. If we have to talk about the things that make it too prejudicial for the public to hear in public, the horse is out of the barn, and you're not achieving that goal of making sure we hear nothing until the jury is impaneled. So the judge points out, well, the problem with that, Mr. Novak, is the sidebar is in fact public because the transcript is public. We already went through this with the October 24th hearing, where they closed the hearing and prepared a transcript. And then instead of us being able to go in and attend that hearing, they went through and redacted the stuff that they felt still too prejudicial for us to be able to see, and then release the transcript. So even the closed hearing, like we get the transcript. He says all that happens with the sidebar is we turn on the white noise, so the audience can't hear it, but it's still being taken down in the transcript. It's in the transcript. It's not private. It's not private. And I know he knows that. I know he knows that. So Mr. Novak says, well, then we would, and that's the case, then we want a brief closed hearing to discuss the specific objections. The judge says, look, I just want to look at the proposed redactions. It's a good time to take our break. Give me the transcript. He's going to read them back in chambers. It's kind of what Mr. Novak, I think, was preparing him for this morning when he told him about the transcript anyway. So they just agreed, well, they'll email it to it. The redactions weren't like done with the blackout. They were done highlighted so they could still read it. He would know, okay, this is what they want out, but he can see what it actually says. Ms. Hunt wants to know, are you ruling on my procedural objection? She does. She doesn't want to sideline the substance. She wants to see if she can kick this out on judge. They're sandbagging us. It's procedurally improper. Judge isn't going to do that. Judge is like, yeah, no, I'm not ruling on anything. We're just taking a break. So we take what he says is going to be a 20-minute break. First it's 15. He's like, no, we'll need a little bit more time. Make it 20. It ended up being almost an hour, which is like the most foreseeable thing ever. Yeah, it's going to take time. I think he ended up actually watching the video. I'm not 100% sure. I just had kind of gotten that impression, but maybe he didn't. Maybe it was all just reading the transcript. So we had a long break during the session. And then when we came back, we addressed what the defense had proffered. I'm going to pause right here just for a minute. I see somebody has already identified the new prosecutor as Lauren Hunt. Lauren Hunt. That's who she is. Okay, good to know. Good to know. It looks like she's going to be playing a role in this. She definitely seems lower on the experience ladder than everybody else that we've seen so far. But I thought she was better than Mr. Sturgill, personally. Mr. Sturgill was one of those prosecutors who struggles to not be leading. He doesn't know how to ask good questions as a prosecutor. Ms. Hunt, just in this kind of brief view that we got, where it wasn't actually that long. She's asking questions of Agent Davis, but we did get some kind of feel for it. Just much smoother, much better at formulating what it is that she's asking for. So I think she's going to probably be fairly skilled. Let's see what you guys got. Harbinger of imminent death. Would a lawyer advise any upside to Mr. Robinson presenting himself to police, answering no questions? Or no arrest warrant equals, stay at home and off the radar? I mean, the job of the lawyer, my view about this particular situation, the job of the lawyer is really to tell you, here are the things you could do, and here are the likely consequences of those choices. Lawyer isn't always going to tell you, here's what I think you should do. It's your choice. Kind of depends on their comfort level. But in terms of things like, you should abscond from justice, they're probably not going to make that recommendation. Now, it's not technically absconding because Tyler hasn't been identified yet. There's no warrant for him. They're not officially looking for him. Nevertheless, like fleeing the jurisdiction, that would not be good advice. It's legally fraught, but it's also, consciousness of guilt. Flight is consciousness of guilt. If they catch you anyway, it's going to look really, really bad. On the other hand, if you turn yourself in, it looks a lot better. If there is a case to be made that this is all a mistake, you look like you were open and ready to deal with it and get out ahead of it. You had nothing to hide. You went and you just, went in and dealt with it. Obviously, the trade-offs involve your personal liberty and a little bit of risk assessment. How likely are they to figure out that it's you? Well, if your parents already think it's you, and you told the Discord, I guess he hadn't told the Discord. He hadn't told the Discord at that point. But either way, your parents think it's you. Probably it's a matter of time. We already heard from Agent Hull the other day. Pretty sure it was Hull, who was talking about all the tips that they got about people that they thought looked like the shooter once the FBI released those photos, and that they were following up on those, trying to clear those out and see if any of them had merit and stuff. So we already knew Tyler was concerned about that because the coworker had texted him the photo. He told that in his text to Lance that are too prejudicial for us to see, even though like most of them are already out there. We'll get to all that. So, how much time are you really going to buy for yourself? And it's going to look worse. It's going to look worse if you don't turn yourself in. If you do, yeah, probably going to charge you. You're going to be in jail. Maybe a couple more days than you would have been if you ran. But it might look better. Puts you in a position where you can color it in a way that's more to your advantage. Harbinger of imminent death. Also, whatever they feed judges in Utah, can we drop some in the judicial water coolers of Massachusetts? Yeah, no massholes on the bench here in Utah, not that I've seen so far anyway. I haven't seen a lot of judges in Utah, good Lord, but just in general, right? Very different vibe. Very different vibe. Now, granted, I do think we are seeing the high caliber. We're seeing very high caliber, attorneys. Judge Graff, yes, is new to the bench. He is new to the bench, but he is not an inexperienced attorney. He's put in his time doing the appellate work and so forth. He's a smart person. He's articulate, pretty good at the job. But the prosecutors, like, these are the best prosecutors in that office. These are some of the best defense, capital lawyers that there are. Over there in Massachusetts, we had Lally. Okay. Lally. We had Brennan. They're no Grunander. They're not even really a McBride. McBride is like the testiest that we've seen so far. And even that, compared to Hank and his bullshit, yeah, it's funny sometimes how the culture, drips over into the courtroom. But as far as Mr. Graff himself, Judge Graff, boy, the patience, yeah, they really could use some of that. It was an issue with Bev. It was an issue with that Kelsey Fitzsimmons judge, whatever her name was. Seems to be kind of becoming an issue with this judge in the Karen Reed case. Been an issue with Turtle Boy's judge, although maybe not quite as much. And he's had a couple, but I kind of vaguely remember one of them being a little on the impatient, obnoxious kind of side. The patience that they have here is really, really commendable. It's a very important judicial quality, and I agree they could use more of that in Massachusetts. Gabe 23G, what about the bullet on top of the other building? They talked about that. It was on top of the computer science building. There's no line of sight, he says, to the tent from that location. And it was a .223 unfired cartridge. So the caliber does not match what ATF is telling us the caliber of the bullet fragments found in Charlie Kirk's autopsy were. Debbie J is working. Thank you so much for the thorough coverage. Love your trial analysis. Debbie, thank you so much for your support. I appreciate that so much. That's a big thank you. I really, really appreciate it. I'm glad to have you here, and I'm just glad that I can share my experience to help other people hopefully understand it a little bit better. Novada Great 1468. Can the press lawyer use Nebraska Press Association versus Stewart? They absolutely can. Absolutely can. That one has come up in the case law as well, in like the previous briefing. Most of like the big landmark, certainly the U.S. Supreme Court landmark cases, every single one of them has come up. In fact, I kind of remember it was Mr. Ballard that brought up Stewart, Nebraska Press Association versus Stewart first. And I kind of remember it because he had when they took this was like early on in the case. I'm trying to remember like exactly how the timeline went. I think it related to that closed hearing that they had in October. When they took the position that I guess stuff should be sealed, private, whatever. And that initial, remember that first time the state was like, we need to close this, and it's because it dealt with the courtroom security and stuff like that. And it was shortly thereafter that Mr. Ballard filed a brief where he's relying on Nebraska Press Association versus Stewart. And it's like, so you know this stuff, dude. You know this. But yeah, so, Nebraska Press Association, of course, Richmond Newspapers is the seminal case. We have the public right of access. Globe Newspapers, another one. The ones we're going to be talking about here this evening and taking a little look at. We're going to look at this Estes case that Mr. Novak talks about. We're going to look at Chandler, which is what I was screaming at the screen. Chandler. Somebody say the word Chandler. And then we're also going to look at Press Enterprise, because Press Enterprise is the one that is the most current in this at the Supreme Court level, and really the most on point to this particular situation. So yeah, all those cases, the judge is aware of the First Amendment stuff. I don't know what the particular variants and nuances are in the 10th Circuit. I've started to look at that. Maybe I'll do a Substack on that at some point. Every circuit, because you have these two sources of public access rights, and not everybody agrees on what applies to what. We have a First Amendment right of access to court proceedings. And then we have a common law right to judicial records. And so because of that, some people are like, your First Amendment right just means you get to go put your butt in a courtroom seat. Has nothing to do with court files. That's under the common law. It's a lower standard, and they're more restrictive of access to court records. Other places like the Ninth Circuit, for example, which was what I briefed in my my filing in old Alice Evans's case, old Malice's case. Ninth Circuit, no, for its First Amendment for all of it. First Amendment for all of it. Criminal, civil, documents, court proceedings, exhibits, all of it is First Amendment. So yeah, there might be some 10th Circuit stuff that hasn't come up yet, but all of this Supreme Court stuff, it's been brought up before. It's just that it's not going to be fresh in the judge's mind, you know, and this isn't his wheelhouse. And it is a lot of cases, and there's a lot of nuance and stuff like that. Janie L. Vargas. Hey, Andrea, could we see a Kohberger redux, i.e. a life sentence that spares him his life, play out with Robinson? Odds of such a plea deal? Absolutely we could. Absolutely we could. So kind of like, well, I shouldn't say that. It's not clear that there were ever any kind of plea discussions in Kohberger until right at the very end. That was kind of the implication that Mr. Thompson gave when he's like describing how this all came about. He says the defense approached them after they'd had all the rulings on the motions in limine and stuff, and they're kind of, you know, getting into their preparation for trial. Defense approached him with the prospect of, you know, could they negotiate a deal? He was willing to take death off the table, not require an allocution or anything like that to give us any sort of more like reassurance that this is legit. But nevertheless, that's kind of how we described it. So that situation sounds like it was really never on the table until the very end. We don't know, you know, at any point if there's conversation receptiveness or not. Now, I have to think somebody who is like voluntarily surrendering themselves to the police, knowing you're going to be prosecuted, you're probably more receptive to a plea deal than the guy who, you know, went back home for Christmas and has the SWAT team busting through his window at 3 o'clock in the morning. And whose like first public statement through his Pennsylvania attorney was, I am going to be exonerated. You remember that? You remember when that first attorney from Pennsylvania, he was doing all those interviews and stuff like that. And a lot of people were like, that's so bad. It's so crazy. I'm like, no, this guy is a baller, man. He's like out there. He's the only one that's pushing back on the, you know, getting his client's version out there. His client says, I believe I'm going to be exonerated. Like not just there's not enough evidence, but they're gonna find I didn't do it. That guy is less likely, you know, to be receptive to a plea deal, so might not expect it early on. I would kind of tend to expect that the guy who's voluntarily surrendering himself so that he can be prosecuted is going to be receptive to the plea deal, but we don't know. We don't know any of those details. We don't know if the state is willing to take death off the table, because that's going to be the key. That's going to be the key. If they don't take death off the table, he has no reason not to go to trial. Because you can't do worse. If you go to trial and lose, what could happen? Death. If you plead to death, you get death. Like, why would you plead? What's the upside? There's no upside. So it depends on all those things. And we talked about this a little bit during the stream today too, that the timing of these things can vary a lot because everybody is weighing, you know, what do I really want to get out of the case? What's in my interest? And what's my risk exposure if we go forward to trial? The prosecutor's thinking, if I got a strong case, I don't need to offer him anything because I can just go to trial and win. But if my case isn't so strong, there's a risk he might get acquitted or he might get convicted of something lesser. Or he might not get death. You know, he might not get death anyway, so might as well plead to it and like save us the expense and everything of all of this. That's the kind of thing they're going to be thinking. But you aren't necessarily going to know that can change over the course of the case. right? It might look like a strong case now, but say a bunch of motions to suppress get granted, and things get excluded in limine, and witnesses disappear, stuff like that. Now suddenly it's a harder case to prosecute, and so you're going to be more willing to take what you can get. Not uncommon at all for criminal cases to settle only at the 11th hour. It's we say sometimes everyone needs to see the whites of the eyes of the jury panel to bring them to their senses. consider their best interests. That's not uncommon at all. Most cases resolved by plea deal. That's no surprise to anybody, but capital cases are always going to be a little bit different because of what's at stake. So giving you that lawyeriest of lawyer answers, it depends. It depends on a lot of stuff we don't know, and also stuff that just has yet to occur. Harbinger of imminent death. Speaking of the 5th, how was the order in the Karen Reed case, where attorneys and parties were required to say what they know about a quote-unquote leak, not a Fifth Amendment violation? Well, I mean, theoretically, they could have invoked the 5th. They could have invoked the 5th. They didn't. So, I mean, that's why it didn't violate the 5th. They didn't invoke. If they were like, took the 5th and then, they invoked, and the court says, I'm not accepting that. I'm going to throw you in jail until you answer as a, as a civil contempt sanction, compel you to comply with my order. Now you got a Fifth Amendment violation, but that didn't happen. So it implicates the Fifth Amendment. Sure, anytime you're asking somebody to give me facts about wrongdoing, tell me what you know about this wrongdoing situation. If you are implicated in that, then yeah, it implicates the 5th, but you have to invoke it. So that's why he's allowed to ask that, because they have the opportunity to say, yeah, no, legally I don't have to, and I'm not going to. 62 sketch. Is it normal for the prosecution to submit this much evidence at a prelim? Seems they're trying to crush as many conspiracies as they can now. Again, it varies, and it's always going to be different in a high-profile case. It's always going to be a little bit different in a high-profile case, just because, yeah, they know people are watching and people are talking, and they also know that it's all going to be handled with a lot more caution. A case that nobody's watching, nobody cares about, just your literal run-of-the-mill volume case going through the criminal court. Just a lot more likelihood that it's going to be handled in a routine kind of way. And so you're going to know, like, oh, this judge will rubber stamp it. This judge might, push back on me, so I need to put on more. I think with a high profile case like this, you're just always going to have the expectation that they're going to be careful. We need to make sure you don't want to underestimate how much evidence you need to put on and then be wrong. So they're gonna err on the side, I think, of putting on a lot rather than putting on a little. Frankly, I don't think this seems like that much evidence. It's what they had. It's what they had when they filed the information. So far, nothing that we've talked about here, nothing I can remember anyway, goes beyond what we knew from the information. I guess the towel and the screwdriver DNA wasn't specifically mentioned, but they did have that. They just didn't call it out. But they did, have other DNA. So, and I guess the ballistics didn't make it into the ballistics. I just mean, they got the 30, they got the bullet fragments, identified them as 30 caliber, so that it's, consistent with Tyler's gun. That wasn't in the information either. So I guess they are going a little bit beyond what they had for the initial charging, but not really a lot. It's just kind of to make sure they have all those links. They want to make sure they have Tyler connected with the campus, Tyler connected with the firearm, the video linking those things, the confession. Circumstances of the surrender is really largely just kind of background, but certainly a person's confessions, if that's what they are, the defense tells us the state's going to say that. State's going to characterize them that way. We're not. I would never call it a confession. You're always going to use that. That standing alone, other than the corpus delicti problem, if you have proof of a crime occurring and a confession, it's probable cause. It's not the strongest probable cause at all, and you better have a lot more than that when you go to trial, but it would technically clear the bar. But I think, they're just substantiating it. They're showing, like, yeah, we got a confession, we got the strong evidence. That in and of itself would get us to probable cause, but you don't even have to worry about, is that enough, because we have all this other stuff that corroborates it. Bass player 2011 IFY, a good lawyer doesn't equal a good judge. That's true. That's absolutely true. They're different qualities. The reason why I bring up his experience as an attorney is because it is that more academic type of practice. PLs are very academic. You read, you write, you research. It's super nerdy stuff when it gets into details of the law. And so, at least in theory, we would expect him to be generally better versed in a lot of basic law, and not just better versed in it, but like better able to find it. It's kind of his wheelhouse. Now, maybe not than Mr. Novak and Mr. Burt, filed hundreds of briefs in federal court and things like that, but you're right. It has absolutely nothing to do with your temperament. Doesn't necessarily mean you're going to have a good judicial temperament. Doesn't necessarily mean you're going to have good judgment about, you're an advocate. You present arguments because you kind of have to, you got to present what's in the interest of your client, do the best you can to try to make it land. But, judge is in a different role. Judge is in a different role. Matthew McClellan, thanks for this week. I'm still at, is there an identity defense? So I've appreciated your logical reasoning approach to the case this week. Grappling with it is helping refine my legal reasoning. I'm glad to hear that. I love logic. I love logic. I don't know if there's an identity defense. I feel like, there would have to be an identity defense if they are going with a, acquit him approach. Because even if it's just poking reasonable doubt in the state's case, that is poking reasonable doubt in the conclusion that Tyler Robinson is the shooter. I think we can rule out that there is any kind of defense on, like, the cause of death of Charlie Kirk, for example. Everybody agrees Charlie Kirk was shot, died of a gunshot wound. Nobody's disputing that. The defense themselves are talking about Charlie being shot. So that's not a defense, The person there with the gun wasn't the cause of death is not a viable defense. So yeah, then you start going into who was the person with the gun, and state says it's you. So if you're going to not be convicted, it kind of has to not be you. Kind of has to not be you. So different ways to do that. Of course, if you had an alibi, that would be super helpful. It's always super helpful for an identity defense. It's not me. Wrong guy, because I was over here, and here's how I prove it. That would be very helpful. In Utah, they don't have to declare an alibi defense until 14 days before trial. So if they are going to try to do something like that, it's nothing we are going to learn in the short term. Highly, highly unlikely that we would know about it. But we can expect that the evidence is available for that type of defense to either be established or eliminated, because they're going to have location data. They're going to have location data from the phone, potentially from the car. Um, so that's gonna be challenging. We know they're gonna have it from the phone because we see the person on the video. They describe it in the PC affidavit. Person on the video pulls the phone out, appears to do something with cell phone. So the person is using the phone. That's a point for them to be able to compare to the data that they have, see if they find something that corresponds with that activity on Tyler's phone. It's just a real clear, easy thing that's available to both of them. And they can both look at. There's something there or there's not. If there's not, defense is going to use that. Could have been him. Look, the guy on the video was using his phone and there's nothing on Tyler's phone that shows him using it at that time. That'd be real straightforward. Therefore, it's not him. That's technically an identity defense. So I think that's largely the direction it's likely to go. Kylie Wilbur 4313, a big nothing burger in trial today, as Blake Neff would say. I don't know that I would call it a nothing burger. I mean, we did get substantiation of this timeline of the surrender, and I mean, I don't think the majority of people in the real world are particularly concerned about internet theories. Nevertheless, the internet theories and commentaries are driving a lot of mood and attitude vis-a-vis Erica. So I imagine, yeah, she is quite interested in these sorts of things being laid to rest. Yeah, nothing real revolutionary today, but obviously that's a factor of the hole that we kind of fell down here with the public access stuff. Well, let's get back to that, shall we? After the break, when Judge Graff came back, he's read everything, took his time doing it. First off, he agrees Mr. McBride's statements in this interview, they are hearsay. However, they're hearsay in the sense that they are out of court statements. But he says he would consider them for non-hearsay purposes. It's only hearsay if it's being offered to prove the truth of what is being said. He says, I would only consider it to give context to what Lance said, which it sounds like is basically like yeah or no, to give context to Lance's testimony, and for the effect that it had on Lance. It motivated him to answer affirmatively or negatively, is the effect that it had. So a little bit of a workaround there. So he overruled the hearsay objection. Vis-a-vis relevance, agrees in some and disagrees in some. He says some parts of it, the relevance is not immediately clear. But the problem is this is an ongoing process. So he, as the magistrate, can, of course, he accepts this argument. He can disregard anything that isn't relevant when he's making his decision. But you can't really make the determination of what's relevant until he's got the whole picture. So, anticipating it could be relevant, he's gonna reserve on this one. He doesn't want to. This is when he told us too. His intention when this is over is he's going to review everything all over again. So we know we're not getting a ruling on Friday. We're not getting a, finding probable cause, no probable cause. Because at the very least, he's going to go look everything back over. So we are likely getting a written ruling and another one of the WebEx hearings and stuff like that. He doesn't want to shoot from the hip. But the relevance is a constant evaluation throughout the process. So he is reserving on this. He points to part of the transcript, pages 19 and 20. He says that might be irrelevant, but he's waiting to see how the rest of the case unfolds. As far as the 403, the more prejudicial than probative, he says it's not the same concern in this situation because he's not the jury. And so for admissibility purposes, no, he can disregard it. It's not going to have an improper effect on him. But he does think there are some portions that could affect the potential jury pool. So he would not be publishing audio, certain portions of the audio. So initially we were talking about timestamp 3255 to timestamp 3548. And then he made a comment that after that, the video only continues for like another minute or so. So we know that we're dealing with a video approximately 38 minutes long. And we also know, or at least suspect, based on what the prosecutor said at the beginning, that part of this interview was like the preliminaries, before they got to the 1102 advisement. So there may be some period of time at the beginning that we're not going to be shown either. So we're talking, about a 30-minute video, roughly total. And now the judge is talking about 3 minutes of it, slightly less than 3 minutes of it, we're not going to be able to hear. But everything else he says can be published. And so for that purpose, the state can just fast forward through it, or they can redact. And so just kind of to clarify, it's all admitted for purposes of him considering it, but he is not authorizing publication of that little 3-minute section. As far as if there is an objection to the admissibility of that section, he says we can do that in the closed hearing. So otherwise he's admitting it, but not publishing it. But if they're saying don't admit it, then they could handle that in the closed hearing. So Mr. Novak responds first. So vis-a-vis the defense concerns, he says, generally there are statements by Lance that he's attributing to Tyler Robinson. He's doing a lot of Mr. Robinson said, as he describes it. There's also these 2 other exhibits that they're quite confident the state is going to offer. We already know it's the text message chain and the chat, the group chat. And Lance says in the video that those are Tyler's statements. So he recognizes under the rules of evidence, those are admissible, even though it sounds like hearsay because it's Lance telling us about Tyler's out-of-court statements. It falls in the exception of the statements of a party opponent. The defendant's statements, like almost always, get to be used against them. Some jurisdictions are a little bit more nitpicky about whether a statement of a defendant to fit within this exception has to be incriminating, like on its face incriminating, a statement against interest, or an admission of some kind. Other jurisdictions, they don't really bother with that distinction. They're just like anything he says, because if you want, I assume if you, the prosecutor, are bringing it in, it's because you think it's bad for him. So you at least think it's incriminating. The whole idea behind this is that you wouldn't make statements against your interest unless they were true. You wouldn't say something that could get you thrown in jail, or something that makes you look real bad or something like that, if it wasn't true. So that's kind of the background justification for having this exception to the rule. But particularly with the party opponent, they just kind of broaden that in a lot of places. So it's basically any statement. So in this case, no question it would be admissible, but of course he's concerned about, can they be published without violating the Fourth Amendment due process rights of Mr. Robinson? And we say no. We say no, you cannot. And he says, we previously cited Estes versus Texas, which says that televising the defendant in the act of confessing to a crime is a violation of the 14th Amendment. Estes versus Texas. Now he says, now I'm not calling these a confession. I'm not calling these a confession, but the state's going to call them a confession. Now we're having it both ways, aren't we? You want the benefit of this rule that is specifically about confessions, and you're saying this isn't a confession, but you should treat it like one anyway. I find that a little disingenuous. Just a little. Just a little. It's very clever. This man is very, very clever. Like, none of this stuff is really out of bounds. None of this is like improper. It's not unethical. But I'm side-eyeing it because I'm like, I see I see what you're doing here. I see the trickery in how you've set this up. Now I know. I don't think I'm going to be able to unsee it. So even though, according to us, they aren't confessions, we still want to invoke the protection that we say this U.S. Supreme Court case gives to confessions. So because of that, it would violate Tyler Robinson's right to not have what the state is calling a confession televised. The judge now pauses, like, what exactly are you referring to? Is this part of the 3 minutes? Is this something else? Mr. Novak saying, no, this is outside of the 3 minutes. And also, by the way, the 2 other exhibits, the text chain and the group chat. He's not going to call those confessions, but the state will. So by the way, like, file this away, because all we talked about today was the video of Lance. That's all that got at least preliminarily ruled on. The exhibits are still out there. They haven't been offered yet. We're going to have to deal with all this again when it comes time to offer those exhibits. So Ms. Hunt at this point verifies that yes, the state is going to move to admit the text thread, the Discord thread, and also the note, the handwritten note. So the judge says, well, I understood that the texts were already released in their entirety. And Ms. Hunt says not all of them are in the probable cause that's in the information. They had selected some, but it's not all of them. And the judge is like, well, I thought they were attached. I thought there were more. I thought they were attached maybe as an exhibit to a motion or something like that. Like, I think you're thinking of the search warrants. Because when the search warrants started coming out and we got the affidavits that supported them, we got more of the texts. They put more of the texts in the search warrant affidavits. So I think that might be what he's thinking about. And yeah, those are public too. They may not be as widespread because they're harder to find, harder to get access to, harder to validate. I haven't gone, to try to dig them up. It's not part of the main court file. Like, search warrants get their own separate file in court, and they make it hard for you to find them. So I haven't gone digging through the warrant records, but I know people have, and so I've seen what they published. It's out there. It's public. They are public records, even if they're a little bit hard to find. But Mr. Novak says, well, that doesn't cure the prejudice of televising it. Televising what they're calling the confession. It's already public. It was in the information. You were complaining about Mr. Gray reading the information in a televised press conference that got lots of attention. So it has already been televised too. And to the extent you said that was a problem, justified removing the cameras and so forth, didn't happen. Nobody agreed with that. But that's his argument. Even if they exist, even if they're in public in writing, even if they're like being published on blogs or something like that, SD says putting it on TV, per se, violation of the 14th Amendment due process rights. So Ms. Hunt says, well, reminder, we don't intend to visually put this up on the monitor. We just want the audio played and for the media to be able to capture that. Mr. Novak thinks that's a distinction without a difference because the problem is the broadcasting. The problem is the broadcasting. We're like, never quite able to solve the problem, are we? The only way to solve the problem is going to be to go full Archuleta and just kick everybody out, right? I feel like he's made that clear. There's just no other solution that would work. And all of this would certainly be, it would go a lot faster, Judge, if you just do that. I feel like they're really signaling that is their breaking point. They're not going to budge. They have to, if they are trying to preserve this for future appellate review. They have to. They can't agree. They can't agree or they waive. So they have to take the hard line on this. I do understand it. I just find the details of how they're making the case a little disingenuous. Ms. Hunt disagrees that it's a distinction without a difference. She says the exhibits are presumed to be public. Granted, it's subject to the court's discretion to limit access, but she thinks that her proposal is a narrowly tailored accommodation of the defendant's interests. We don't want the video so that it could be screenshot and essentially copied and disseminated everywhere. So that's why we're saying just do the audio. That's our accommodation. And Mr. Novak says, well, it's fair for her to say that we want the court to be able to see and hear the witnesses, but that's different from the electronic media coverage, everybody in the world seeing it. And of course, it's not about the state standards and what they say about getting exhibits and sealing and things like that, because it's a constitutional magnitude. And that's why SD says you can't publish a confession before the trial. Can't do it. That's what SD says. So the judge is listening to all this, and the judge decides, okay, then I guess further edits are going to be required. And take some time to look through and identify what the further edits are going to be. And now we have timestamp 656 until 2027. 666, I gotta think, is like not real long after we've gotten through the preliminaries. I would expect we've gone through the basic introductions. We have given the 1102 advisement, and now we have started talking about what you're here to tell us about. So we would like maybe get to see the 1102 advisement, and then 14 minutes of the interview, 13 and a half minutes that we wouldn't get to see. Plus the 3 minutes that he already said we're not going to get to see. So 16 and a half minutes that we're not going to get to see. Look at that. Look at that. Little more than probably half of the video. Kind of sounds like exactly what the defense was asking for. 11 pages of the 20-page transcript. A little bit over half. Well, at this point, the media lawyer pops up. Glad to hear from him. I'm screaming Chandler. He doesn't give us any case law, but he just says, I got two things. I just got two things. First, if this is in fact a key consideration for the probable cause determination, then even the Archuleta case says that just access to the preliminary hearing itself kind of requires access to the documents on which the court bases its decision. Like even Archuleta recognizes that's what the First Amendment right is about. You need the basis, or the First Amendment function is not being fulfilled. And then second, without going into the content of the thing, because he doesn't know the content of the things, he understands many of the references are to texts. The documents filed in this case contain many, if not all of them. So it's already in the public. Is there maybe, if there's something else lurking in there that we don't see? Could be, but everything else that's already public, it's already public. It's already public. It's already out there. Some reason why it's like inherently more prejudicial if it's public to blast it out, have it on the live stream on the court feed that us diehards are going to watch and talk about, but not necessarily anybody else, versus somebody makes a public record request, somebody with, I don't know, maybe somebody with a big channel, much bigger than mine. Somebody with a big channel does a public records request, gets the search warrants, does a whole show on the texts to millions of people. Like, that's fine. That's allowed. It's a public record. It's already available. It's out there. But somehow it gets converted to a fundamental, per se, due process violation for a television camera in the courtroom to do the same thing, even if the audience is smaller. I don't follow or buy this reasoning. But then we also heard from Jeff Nyman. Jeff Nyman is Erica Kirk's lawyer. He's the one that has represented, he's entered his notice of appearance on her behalf as the victim representative. He has a say, and he says right off the bat, I have not asserted myself here, right? I have been hesitant to speak up. They've been sitting there. It's not their place to get involved. But he says, our position, we believe strongly that the evidence being admitted in this proceeding should be public for all to see. And he got very impassioned, very impassioned. He says, to not be transparent here will create doubt and distrust in the judicial system. And nobody wants that. We don't want that. Nobody wants that. We want to be able to trust this process. Oh, I was like, stand and applaud. Stand and applaud. Hear, hear. Yeah, that's the whole problem, isn't it? That's the whole problem. Trying to remember what the real power begins where secrecy begins, I think is the quote. Hannah Arendt, Origins of Totalitarianism. You want to control people's minds? You control information, control the truth. This is not like revolutionary thoughts. George Orwell showed it all to us in literary form. Hannah Arendt talked about it in a more, philosophical type of sense. But yeah, that's concerning. That's concerning. It's an authoritarian trend to keep things secret, particularly things that we should have a right to know. Mr. Novak speaks again. Oh, we totally respect her position in the situation. It's just that media counsel's suggestion that the state improperly, in our view, disclosed all of these texts in the charging document shouldn't be like justified now, or like everything's okay now because they did a thing that they shouldn't do. That's the defense position about it. I saw a cat coming to eat the paper that I dropped. You want to come up, Gus? You want to come up and say hi? Let me get him. He's a lazy boy. He doesn't want to jump up by himself. Oh, did I say that about you in public? Did I say that about you? I did. Maybe he doesn't actually want to be up here at all. He says, this is the most transparent case I've ever been involved in. I was screaming, yeah, that's because you moved to seal everything in federal court and they let you do it. That was certainly one of the things I saw when I was doing my research into Mr. Novak's background. A lot of those cases in Pacer, whole massive amounts of it sealed off. Ironic too, because like I said, Ninth Circuit is supposed to be kind of one of the most favorable jurisdictions as far as these things go. They just seal it off and just leave it sealed, probably until somebody comes along and asks to unseal it. You gotta appear in federal court, file a motion in federal court, argue it to the judge. How many people are going to do that? So yeah, I'm sure it has been the most transparent case he's ever been involved in. He says, but there's certain evidence that the public just has to wait for trial to hear it. Number one concern has to be Tyler Robinson's right to a fair trial and that the jury is not exposed to pretrial information of this nature. So Judge Graff, he's got a question about Estes, right? Because everybody's been sandbagged here. Nobody briefed this. We're just throwing legal authority out on the fly. And so he's up there like trying to read it on the bench and make sense of it. And he says, Estes, I have a question because it cited a dissenting opinion in this other case, Rideau versus Louisiana. And he said it's more about coerced confessions being put out to the public. And Mr. Novak says what the court says in Estes is that televising what the state is calling a confession per se violates a due process right. And he says it's complicated because this was a plurality decision in Rideau, and he doesn't call it a plurality decision. That's what it is. It's when you don't have a majority of the court adopting a single opinion. You have a majority adopting an outcome, but for different reasons. So you have a whole bunch of different opinions setting forth different reasons. And you have to kind of map it out to figure out if any of it actually got a majority that would make it binding law, like precedential authority. So he's like describing, this person did this person did that, and so forth. So the judge now reiterates the timestamps that he intends to not allow to be published. 6:56 to 20:27, 13 and a half minutes of the video, and then 32:55 to 35:48, approximately another 3 minutes. He says, responding to the media and Mrs. Kirk, I recognize the importance of transparency. The balance of rights is a fine line. The 403 issue that he is perceiving, he says, the more prejudicial than probative. We've looked at this language before. It's got a lot of different considerations that can justify, even if it's relevant, we're not going to do it. And he's pointing to cumulative. It's cumulative. And so why is it cumulative? Well, because based on the texts that are being introduced. And so we can revisit it if that doesn't happen. The defense has already told us we're going to be going through this song and dance with the texts and the chats anyway. We're going to be doing the same thing with those. And it doesn't make any sense at all if the ruling is that it's too prejudicial for it to be televised, then it doesn't matter what format it's in. Whether it's being verbally communicated by somebody in this 1102 video statement or whether it is in writing as an exhibit for us to see for ourselves. So this was a kicking the can down the road that seemed also a bit disingenuous. It's a dodge. It's an excuse. It's a suggestion that we might fix this. But I'm really not seeing a pathway. It's not like he's saying we could revisit this if that doesn't happen, if they don't offer the text? They're going to offer the text. So we don't get to see it because it's cumulative. You're probably not going to let us see the text either. The same reasoning applies. If you've bought what the defense has to say here as to the video, then I just don't see how you're going to be able to distinguish the same thing in written form, in text form. But he does say much of what he is redacting basically is the text messages. To be clear, much of it is the text messages. So I mean, I guess that's a little cold comfort because, yeah, the text messages are already out there. And so if we're mostly talking about reading the texts and just having Lance confirm yes, no, those are the text messages, then it isn't adding anything that we don't already know. So it's not really hurting us, I guess, to not hear it. But we are really taking the judge word for that. And the word much of this, much of this, that's carrying a lot of water. How much? How much? We know the 3 minutes are something else. Lance privacy issues. We have a general idea of what that likely relates to, but not, the full story or context or anything like that. Are you saying the rest, as in the 16 and a half minutes, is all text messages? He's not going to be specific about that. And unfortunately, my trust in Judge Graff is really, really rattled right now. I don't know that I can trust his characterization of much as being like it's not anything for me to worry about. So as far as how they want to proceed with it, he offered, do you want to fast forward? Do you want to present the transcript? Do you want to take the time to edit it? And we can, move on and present the edited version after you're able to do that. So Ms. Hunt says what they want to do is edit it this evening, and then they will play it the first thing tomorrow. And as for right now, we want to just close for the day. Close for the day so they can go back to the office and do all this freaking editing. Right? Mr. Novak then says, and they think there's one additional exhibit that they think they will offer through Agent Davis, to which they propose redactions. It consists of 5 screenshots from Lance's phone. He's saying not saying let's argue it now, but just making the court aware, and Estes covers that too. Covers all statements by Lance in the interview, in the chat, in the note, in the text, etc. So we're going to be having the same conversation about other stuff. Could not be more clear. I know that. So think about that, Judge, when you say we can revisit this. Everyone's kind of telling you how this is going to go, and I'm not seeing how a note that I don't suspect you're going to let us see it. I just don't. So how would that cure? How's that revisiting not being able to hear the text on the audio? I don't know. So then the judge requested of Mr. Novak, would you mind preparing a memo that would help me to move forward? A memorandum. Do what you should have done with this issue in limine. Brief it. Give notice. Brief it. Write it down so that we're not having to do this on the fly. He says, I want to look at what you're saying in detail. And he says, oh yes, I'll try to do that. I'll work on it. I'll try to get it to the court by 8 a.m. 8 a.m. so that the state has an hour with it before they got to be in court tomorrow. But, the judge invites the state to, also file a brief if they want to. Didn't invite the media. I nevertheless hope the media files a brief. So yeah, I'm going to be monitoring the exchange tomorrow morning, like from the moment I wake up, which is hopefully not going to be crazy early. Look at that. We're like 10 minutes before 10 o'clock, but we got cases to look at. We got a little bit more to go. So I will keep an eye on the exchange for those, the docket for those filings, and try to grab them and get them up on the Substack as soon as possible so that we have those available, because this is going to be an ongoing theme. They're telling us crystal clear. Whatever you do with this video, Judge, we're going to be asking you to do the same thing with all this other stuff. And so if you're thinking us not seeing the video is going to be rectified by this other stuff, guess again. Guess again, because they're going to be making the same argument that televising any of it is a fundamental due process violation. So why don't we look at the merits of that claim, shall we? Shall we go ahead and take a look at it? Let's start. Oh boy, is here where we're starting? Yes, here's where we're going to start. This is the case that he was talking about, Estes versus State of Texas. 1965. Not quite 20 years before the U.S. Supreme Court started getting really into this First Amendment access to courts jurisprudence, which had its heyday in the early 80s. It's when a lot of the big decisions were being made. The petitioner stands convicted in the district court for swindling, whether he was deprived of his right under the 14th Amendment to due process by the televising and broadcasting of his trial. Oh, wait a second. His trial. Are we in trial? Are we in trial? Mr. Novak has been saying this case holds that it's a due process violation to televise a confession in advance of the trial, right? Let me see if I got his exact words, or at least close enough. I guess maybe he doesn't. Maybe he doesn't go that far. He just says, according to Estes, televising the defendant in the act of confessing to a crime is a violation of the 14th Amendment. Okay. I don't want to misconstrue his argument. So, factually, we're in a little bit of a different context, but that may or may not be legally significant or not. So we're going to skip this part about judicial canons and stuff like that, because what they're concerned about here is the 14th Amendment, and that's the issue. So his case was called for trial on September 24th, 1962, after a change of venue, massive pretrial publicity totaling 11 volumes of press clippings, which are on file with the clerk, had given it national notoriety. All available seats in the courtroom were taken, and some 30 persons stood in the aisles. However, at that time, a defense motion to prevent telecasting, broadcasting by radio, and news photography, and a defense motion for continuance were presented. And after a 2-day hearing, the former was denied and the latter was granted. These initial hearings were carried live by both radio and television, and news photography was permitted throughout. Videotapes of these hearings clearly illustrate that the picture presented was not one of that judicial serenity and calm to which petitioner was entitled. We have a Shepard v. Maxwell situation. It's a circus. It's chaos. They let the cameras take over and run the show. At least 12 cameramen were engaged in the courtroom throughout the hearing, taking motion and still pictures, televising the proceedings. Cables and wires were snaked across the courtroom floor. 3 microphones were on the judge's bench, and others were beamed at the jury box and counsel table. It is conceded that the activities of the television crews and news photographers led to considerable disruption of the hearings. Moreover, veneermen had been summoned and were present in the courtroom during the entire hearing, but were later released after petition's motion for continuance had been granted. The court also had the names of the witnesses called. Some answered, but the absence of others led to a continuance of the case until October 22nd, 1962. It is contended that this 2-day pretrial hearing cannot be considered in determining the question before us. We cannot agree. Pretrial can create a major problem for the defendant in a criminal case. Indeed, it may be more harmful than publicity during the trial, for it may well set the community opinion as to guilt or innocence. Though the September hearings dealt with motions to prohibit television coverage and to postpone the trial, they are unquestionably relevant to the issue before us. All of this was highly publicized, could only have impressed those present with the notorious character of the petitioner as well as the proceeding. The trial witnesses present at the hearing, as well as the original jury panel, were undoubtedly made aware of the peculiar public importance of the case. by the press and television coverage being provided and by the fact that they themselves were televised live and their pictures rebroadcast on the evening show. When the case was called for trial, the scene had been altered. A booth was constructed at the back, painted to blend in with the permanent structure of the room, had an aperture to allow the lens of the camera an unrestricted view of the courtroom. All television cameras and newsreel photographers were restricted to the area of the booth when shooting film or telecasting. So now they've calmed down, they've eliminated the circus environment, they've made this a little bit more consistent with the decorum of the court. Because of continual objection, the rules governing live telecasting as well as radio and still photos were changed as the exigencies of the situation seemed to require. As a result, live telecasting was prohibited during a great portion of the actual trial. Only the opening and closing arguments of the state, the return of the jury's verdict, and its receipt by the trial judge were carried live with sound. Although the order allowed videotapes of the entire proceeding without sound, the cameras operated only intermittently, recording various portions of the trial for broadcast on regularly scheduled newscasts later in the day and evening. At the request of the petitioner, the trial judge prohibited coverage of any kind, still or television, of the defense counsel during their summations to the jury. So we got a cherry-picked trial. We've got not a complete trial, not a complete picture of what's happening in the court, but we've got some cherry-picked stuff. And so we can assume what they want is the juicy, the salacious, the big headlines. That's what they're going to be paying the most attention to. Because of the various restrictions, the telecasts of the trial were confined largely to film clips shown on these regularly scheduled news programs. They would use it as a backdrop for the commentary for the news reports. And the commentary included excerpts from testimony and the usual reportorial remarks. On one occasion, the videotapes of the September hearings were broadcast in place of, quote, the late movie. Not the late movie. So 1965. So look, so here we go. Here we go. In Rideau versus State of Louisiana, this court constructed a rule that the televising of a defendant in the act of confessing to a crime was inherently invalid under the Due Process Clause of the 14th Amendment, even without a showing of prejudice or a demonstration of the nexus between the televised confession and the trial. This means per se prejudicial. You don't have to prove it. The court's going to assume it is by virtue of the fact that the camera captured this. So here's our first little issue. Estes is telling us Rideau said that. Did Rideau actually say that? Let's go ahead and switch over real quick and look at Rideau. Let's look at Rideau. He had a filmed interview. It lasted 20 minutes. He was interrogated. Later the same day, the filmed interview would broadcast over a television station in Lake Charles, and some 2,400 people in the community saw it and heard it on television. The sound film was again shown on television the next day to an estimated audience of 53,000 people. So yeah, this is messed up. This is like they interrogated him, recorded it, and then linked it to the press. And the press, published it all over locally. Following day, the film was again broadcast by the same television statement, and this time approximately 20 people saw and heard the interview on their television sets. This parish, I'm not going to try to say that, Calcasieu, I'll say it. I mean, it's just French. French is a beautiful language, you French haters out there. C'est très joli. Has a population of approximately 150,000 people. So a lot of these people, we don't know, of course, how many of them are repeats, but, at least a third of people in the county, in the entire county saw it. 2 weeks later, he's arraigned, he's charged. His lawyers promptly filed a motion for a change of venue. on the ground that it would deprive him of rights guaranteed to him by the United States Constitution to force him to trial in Calcasieu Parish after the 3 television broadcasts there of his interview with the sheriff. The motion for change of venue denied. He was convicted, sentenced to death. 3 members of the jury said they had seen the interview on at least one occasion. 2 members of the jury were deputy sheriffs of the parish. His counsel had requested that all these jurors be excused for cause, having exhausted all of their peremptory challenges, but the judge denied those challenges for cause. The record in this case contains an exhibit. As an exhibit, the sound film which was broadcast. So what they saw on their television sets was Rideau in jail, flanked by the sheriff and 2 state troopers, admitting in detail the commission of the robbery, kidnapping, and murder in response to leading questions by the sheriff. The record fails to show whose idea it was to make the sound film and broadcast it over the local television station, but we know from the conceded circumstances that the plan was carried out with the active cooperation and participation of the local law enforcement officers. Yeah, no shit. And certainly no one has suggested it was Rideau's idea or even that he was aware of what was going on when the sound film was being made. In the view we take of this case, the question of who originally initiated the idea of the televised interview is in any event a basically irrelevant detail. We're not going to be like, what the fuck is the matter with you, cops? Irrelevant? Irrelevant. Sorry, but I got to scroll up real quick. We're only in 1963 in Louisiana. 1963 in Louisiana. Wrongdoing by the cops, irrelevant detail. That's not where we're going to focus our attention on this issue and the problem it created and how to resolve it and so forth. Now, that's irrelevant. Oh, I'm already done with this court. For we hold that it was a denial of due process of law to refuse the request for a change of venue. After the piece of Calcasieu Parish had been exposed repeatedly and in depth to the spectacle of Rideau personally confessing in detail to the crimes with which he was later to be charged. For anyone who's ever watched television, the conclusion cannot be avoided that this spectacle to the tens of thousands of people who saw it and heard it in a very real sense was Rideau's trial, at which he pleaded guilty to murder. Any subsequent court proceedings in a community so pervasively exposed to such a spectacle could be but a hollow formality. This is about a change of venue. This is about a change of venue and oversaturation in the jury pool and letting people on the jury who shouldn't have been on because they'd been exposed to it. Let's continue. Brown v. Mississippi, the court set aside murder convictions, secured in a state trial with all the formalities of fair procedures based upon free and voluntary confessions, which in fact had been preceded by grossly brutal kangaroo court proceedings while the defendants were held in jail without counsel. Chief Justice Hughes wrote in that case, the state is free to regulate the procedure of its courts in accordance with its own conceptions of policy, but it does not follow that it may substitute trial by ordeal. That was almost a generation ago in an era before the onrush of an electronic age. The case before us now does not involve physical brutality. The kangaroo court proceedings in this case involved a more subtle, but no less real deprivation of due process of law. Under our Constitution's guarantee of due process, a person accused of committing a crime is, I hate to want to pronounce this because I'm not sure. It's one of those words I've read a million times. I don't think I've ever heard anybody say it out loud. Vouchsafed. Ugh. Basic minimal rights. Among these are the right to counsel, the right to plead not guilty, and the right to be tried in a courtroom presided over by a judge. Yet in this case, the people of Calcasieu Parish saw and heard not once but 3 times a trial of Rideau in a jail presided over by a sheriff, where there was no lawyer to advise Rideau of his right to stand mute. The record shows that such a thing as this never took place before in Calcasieu Parish, Louisiana. Whether it has occurred elsewhere, we do not know, but we do not hesitate to hold without pausing to examine A particularized transcript of the voir dire examination of the members of the jury that due process of law in this case required a jury trial before a jury drawn from a community of people who had not seen and heard Rideau's televised interview. Due process of law, preserved by all for our Constitution, commands that no such practice as that disclosed by this record shall send any accused to his death. This is the opinion of the court from Stewart. It's about the jury and the jury's exposure. Nothing in this opinion of the court, the main opinion of the court, the part that's binding law, holds that it is a per se due process violation under any and all circumstances to televise a person's confession. It says if that happens and it permeates the community and as a result you end up with tainted jurors, that's a due process problem. If you don't move the trial or do something else to make sure that you actually have a fair jury. So that's Rideau. Then we have these dissenting opinions. But these aren't law. These aren't law. The dissent says, I must part company, not so much because it deviates, because it simply stops. It doesn't establish any substantial nexus between the televised interview and petitioner's trial, which occurred only 2 months later. Unless the adverse publicity is shown by the record to have fatally affected the trial, there is simply no basis for the court's interference. The dissent is disagreeing with the outcome, right? They're saying, no, we wouldn't reverse this. We would go ahead and let this stand. We think it's fine. We think it's fine. So already I'm like, we got a little bit of an issue here with Estes because it's saying that Rideau did something that Rideau didn't do. Rideau didn't do this. It didn't say per se, every circumstance. It literally said in this case, and this case involves a tainted jury and a denial of a change of venue. Here, although there was nothing so dramatic as a home-viewed confession, there had been a bombardment of the community with the sights and sounds of a 2-day hearing during which the original jury panel, the petitioners, the lawyers, the judge was highly publicized, emphasized the notorious character that the trial would take. So it continues. We start with the proposition that it is a public trial that the Sixth Amendment guarantees to the accused. Purpose of this, so that you would be fairly dealt with. Secret tribunals are effective instruments of oppression. Yeah. Quotes, quotes, quotes. It is said, however, that the freedoms granted in the First Amendment extend a right to the news media to televise from the courtroom, and that to refuse to honor this privilege is to discriminate between the newspapers and television. This is a misconception of the rights of the press. So some conversation about that. This is no longer controversial. There's no constitutional right to televise. No constitutional right to televise. So they're not going to consider it discriminating to let print reporters in, but not news cameras. Court proceedings are held for the solemn purpose of endeavoring to ascertain the truth. We have safeguards. As a result, at this time, those safeguards do not permit the televising and photographing of a criminal trial, save in 2 states, and they're only under restrictions. The federal courts prohibit it by a specific rule and still do. This is weighty evidence that our concepts of a fair trial do not tolerate such an indulgence. We have always held that the atmosphere essential to the preservation of a fair trial, one of the most fundamental of all freedoms, must be maintained at all costs. Our approach has been through rules, contempt proceedings, and reversal of convictions obtained under unfair convictions. Here, the remedy is clear and certain application, and it is our duty to continue to enforce the principles that from time immemorial have proven efficacious and necessary to a fair trial. So then they, state says it's not a violation of due process. Distractions, considerations, yada yada. They don't agree with that. At the outset, the motion should be dispelled that telecasting is dangerous because it is new. Yeah, we don't know. But the issue isn't newness, it's the insidious influences which it puts to work in the administration of justice. So they detail these below. Yeah, we have the right to know, but reporters are free to report. And that's fine. Legal publicity, it's okay. You can see in print. And the state says no prejudice here from having the TV. But the court says, no, we have found instances in which a showing of actual prejudice is not a prerequisite to a referral. There are situations where the court will find per se violations of a constitutional right without prejudice. Very, very limited. But guess what? This is such a case. It is true that in most cases involving claims of due process deprivations, we require a showing of identifiable prejudice to the accused. Nevertheless, at times, a procedure employed by the state involves such a probability that prejudice will result that it is deemed inherently lacking in due process. So, biased judge, when you have a judge with an actual conflict of interest, structural error, per se violation. You don't have to show prejudice. It's presumed. This rule was followed in these other cases, Rideau, etc. No showing of prejudice required. I feel like there was pretty obvious prejudice in Rideau. You had biased jurors. You had biased jurors that were allowed on the panel. That's like a big problem for me. 2 cops and 2 people that saw it, 3 people that saw it. In this case, it's even clearer that such a rule must be applied. In the other cases, the pretrial publicity occurred outside the courtroom and could not be effectively curtailed. The only recourse other than reversal was contempt. In this case, the application of the no prejudice principle is especially appropriate. Television in its present state and by its very nature reaches into a variety of areas in which it may cause prejudice to an accused. Still, one cannot put his finger on its specific mischief and prove with particularity wherein he was prejudiced. We just don't like it. We don't like it. We can't say why. Can't say why. But we don't like it. His trial got televised and we don't like it, even though, like, they did it with decorum. Seems like they followed the rules vis-a-vis what they were told they could film and not film. But they just don't like it. Can't really say why. As has been said, the chief function of our judicial machinery is to ascertain the truth. The use of television, however, cannot be said to contribute materially to this objective. I could not disagree more. Rather, its use amounts to the injection of an irrelevant factor into court proceedings. In addition, experience teaches that there are numerous situations in which it might cause actual unfairness, some so subtle as to defy detection by the accused or control by the judge. So, some of those potential impact on the jurors, they're aware that they're being watched. They're aware that people know what they're going to be doing, particularly if they're on the camera and everybody knows who they are. They might see it. They might see it. Yeah, there's a sequestration rule that would apply here, but there's other states that don't have that rule. And, it's possible they might get exposed to it anyway, that kind of thing. And finally, new trials plainly would be jeopardized in that potential jurors will often have seen and heard the original. Oh, so if you have to do it again, like 2 years later, everybody who watched it the first time still lives there and is going to remember and all that. And that can't be sorted out through jury selection. Yikes. The quality of the testimony will be impaired because the witness, knowing that he is being viewed, the impact is incalculable. Some may be demoralized and frightened, some cocky and given to overstatement. Memories may falter. I feel like this is the case in any public setting. This is the nature of people not accustomed to public speaking, being put on a stand in front of a big audience of people and being expected to talk. The camera is an abstraction. You know, the 200 eyes staring at you from the gallery are going to have that effect. It's going to make it real obvious. The camera is just kind of abstract. You don't really know how many people, you don't see the people watching you through it. Anyway, this is their objection. And the invocation of the rule against witnesses witness sequestration, it would be jeopardized. They could see it. They'd be able to see it. It would be available. Yeah, that also happens with newspapers, but there's also just, the solemn decorum of the court. It's our magic word. The solemn decorum of the court intrudes upon it. It's far more serious than only newspaper coverage. Why? They say so. Why? Because we say so. No real good explanation here for why this is so undignified. And then, it's going to distract the trial judge and then impact on the defendant. Presence is a form of mental, if not physical, harassment, resembling a police lineup or the third degree. The inevitable close-ups of his gestures and expressions might well transgress his personal sensibilities, his dignity, and his ability to concentrate on the proceedings before him. Sometimes the difference between life and death, dispassionately, freely, and without the distraction of wide public surveillance. Yeah, I don't disagree with a lot of this. The whole, let's focus on the defendant and dissect every minute expression. Not always a fan of that. But look what they're doing in this courtroom. You just don't allow that. You just don't allow that. It's not rocket science. Just don't allow them to do that. Just because there is a camera in the courtroom doesn't mean there is automatically free reign. You're forced to allow the camera to run the camera operation in the courtroom. You, the judge, can restrict that. Can't even get into how many defendants want to be on TV. Do you think Ted Bundy felt that his personal sensibilities and his dignity was affected, undermined by the cameras in the courtroom? Hell no. Hell no. He's having the greatest time up there playing that role. I don't know that that's an argument for having cameras, but I just kind of point out, I think some of these assumptions may not be so solid. A lot of talking about the TV, blah, blah, blah. So the facts in this case demonstrate clearly the necessity for the application of the rule announced in Rudeau, which you've kind of misstated and not real clear what you mean other than some things don't require a showing of prejudice, but we aren't dealing with a motion for a change of venue. We're just dealing with a guy who had a normal trial that was on TV. But also, the courtroom was a mass of wires, television cameras, microphones, and photographers. Well, it sounds like for the pretrial hearing it was, but then they resolved that for the trial. Nevertheless, no restrictions, emphasize the notoriety, emphasize the publicity. It was televised beginning 30 days later, inherently prevented a sober search for the truth. How? How does seeing what happened in the court inherently prevent a sober search for the truth? We are watching what you just told us is a sober search for the truth taking place in the courtroom. The judge himself was harassed? Well, that's not good. That's like a whole separate problem. So then he did the booth, made all these rulings, resulted in a public presentation of only the state's side of the case. The defense didn't want to be publicized. The defense didn't want their side of the case out there. It is just kind of wild. So, bottom line, holding from Estes, per se, No showing of prejudice required. Televising a trial, period. Period. We started from Rideau, where you televise the confession and it taints the entire community. And then you end up with a tainted jury. To this, TV per se. Per se, there's no problem. Literally no problem. I think that's the whole point. That's why they have to apply the rule, because like it didn't actually cause much of a problem here. How did it affect the trial? It caused a minor annoyance. But nothing about this that suggests in any way it like affected the evidence that came out or how the jury deliberated, what they knew. Estes was wild. This is like clear courts having a little stick up the backside, not liking, not thinking it comports with the holy sanctum of the courtroom. Diminishes it, demeans it, makes it too accessible to the masses. That's a bad thing. Yikes. That's what Estes held. So I was screaming all day, Chandler, 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 Chandler. Let's look at Chandler v. Florida, shall we? The Florida, well, this is the syllabus. We'll go to the opinion. The question presented on this appeal is whether, consistent with constitutional guarantees, a state may provide for radio, television, and still photographic coverage of a criminal trial for public broadcast, notwithstanding the objection of the accused. Can they? Under Estes, it really sounds like they can't. Per se violation to have it on TV. Didn't even have to show any problem with the trial. Go back and retry him without the cameras. That's what Estes said. So they review kind of how things have developed. Lots of criminal cases been covered by the media, including televised proceedings. There's these judicial canons that were adopted that suggested it should be barred, should not allow broadcast of courtroom proceedings. Code of Judicial Conduct replaced it, but they adopted the same canon in 1962. Then in 1978, they proposed revised standards that included a provision permitting courtroom coverage by the electronic media under conditions to be established by local rule and under the control of the trial judge, but only if it was carried out unobtrusively and without affecting the conduct of the trial. Revision was endorsed by the ABA Standing Committee. It was rejected by the House of Delegates. Then the Conference of State Chief Justices voted to adopt the highest resolution to allow the highest court of each state to promulgate standards and guidelines regarding this type of coverage. So authorizing them to go ahead and set up rules to let you do it. So then we have the Florida program. And they requested, to revise these proceedings, and the Florida Supreme Court said, okay, we will do a pilot program. Continued through June 1978. They did all of this studying, surveys, things like that. Following review of this material, it concluded, on balance, there was more to be gained than lost by permitting electronic media coverage of judicial proceedings, subject to standards for such coverage. The Florida court was of the view that because of the significant effect of the courts on the day-to-day lives of the citizenry, it's the most likely place where you're going to intersect with one of our branches of government. If you have to go to court, somebody gives you a ticket, you got to go to court. You're going to get divorced, you need to go to court. Somebody dies and you need to probate it, you need to go to court. It's like by far where people intersect with the power of government. It was essential that people have confidence in the process. It felt that broadcast coverage of trials would contribute to wider public acceptance and understanding of decisions. Consequently, after revising the guidelines to reflect its evaluation of the pilot program, it promulgated a revised canon that basically allows electronic media and still photography coverage subject to, the court's authority to control the process. So this is our background. This is how Florida does it, and they set up these all specific rules for how we're going to do it. So now we're in July 1977 with these appellants charged with conspiracy to commit burglary, grand larceny, and possession of burglary tools based on breaking and entering a well-known Miami Beach restaurant. Not a routine burglary. The appellants were Miami Beach policemen. The state's principal witness was this amateur radio operator who, by sheer chance, had overheard and recorded conversations over their police walkie-talkies during the burglary. Not surprisingly, these novel factors attracted the attention of the media. Yeah, I think so. Cops breaking and entering into a restaurant and only getting caught because they are using their law enforcement provided equipment and bandwidth to carry out the crime. Yeah, I'd say that would generate some public interest. They tried to have the canon declared unconstitutional on its face and as applied. They sent it up to the Florida Supreme Court. Florida Supreme Court says we're not gonna rule on it. So ultimately, they selected the jury, asked if they could be fair and impartial despite the presence of a television camera. Every juror said it's not going to affect me either way. Had a request for sequestration, denied. Television camera was in place for one entire afternoon, during which the state presented the testimony of the amateur radio guy, its chief witness. I don't know if it's Cian or Cyan or what. No camera was present for the presentation of any part of the case for the defense. So that part is like Estes. And then it returned to cover closing arguments. Only 2 minutes and 55 seconds of the trial below were broadcast, and those depicted only the prosecution's side of the case. The jury convicted. Appellants moved for a new trial, claiming that because of the television coverage, they had been denied a fair and impartial trial. No evidence of specific prejudice was tendered. Florida Supreme Court affirmed. It said the canons are fine, but they certified it up to the Florida Supreme Court. Florida Supreme Court said, nope, we adopted the revised rule, so to the extent this appeal is challenging the old rule, it's moot. It's moot, so we're not going to consider it. So it goes up to the U.S. Supreme Court. So Florida, first off, in deciding to adopt this rule in the first place, pointedly rejected any state or federal constitutional right of access on the part of photographers or the broadcast media. They didn't say the press has a constitutional right to come in and film. That wasn't the justification. They basically just said, we think it's a good thing. We think it's beneficial, so it should be allowed subject to these limitations, but not that there's a right to it. So this court, U.S. Supreme Court, doesn't get into the internal state court administration. Their sole role is to evaluate if there is a federal constitutional problem here. That's the scope. That's the scope of their jurisdiction. So nitpicking over like how the canons were adopted and all those types of things, not going to matter here. Bottom line, do we have a due process violation? Check this out. Appellants rely chiefly on Estes versus Texas and Chief Warren's separate concurring opinion in that case. They argue that the televising of criminal trials is inherently a denial of due process, and they read Estes as announcing a per se constitutional rule to that effect. That's kind of what Mr. Novak was saying today too, wasn't it? Per se, due process violation to televise the confession based on what it said about Rideau that was kind of incorrect and is dicta anyway. Dicta meaning it's a part of the opinion that is not essential to the holding. What the court is actually doing in this case. kind of dicta. The concurring opinion says, I join the court's opinion and agree that the televising of criminal trials is inherently a denial of due process. I desire to express additional views on why this is so, and our condemnation of televised criminal trials is not based on generalities or abstract fears. The record in this case presents a vivid illustration of the inherent prejudice of televised criminal trials and supports our conclusion that this is the appropriate time to make a definitive appraisal of television in the courtroom. So that was the concurring opinion. If appellant's reading of Estes were correct, we would be obliged to apply that holding and reverse the judgment under review. It got televised. Estes says per se violation. Therefore, we have no choice. We got to reverse it. That's what we would have to do. But Estes, plurality, 6 separate opinions, must be examined carefully to evaluate the claim that it represents a per se constitutional rule forbidding all electronic coverage. Goes through and kind of maps all this. Here's what the different opinions do and say. We're not going to go in through all those details. Parsing the 6 opinions in Estes, one is left with a sense of doubt as to precisely how much of Justice Clark's opinion was joined in and supported by the other ones in an area charged with constitutional nuances. Perhaps more should not be expected. Nonetheless, it is fair to say that Justice Harlan viewed the holding as limited to the proposition that what was done in this case infringed on the fundamental right to a fair trial, assured by the Due Process Clause of the 14th Amendment. That's what it said. At the present juncture, I can only conclude that televised trials, at least in cases like this one, possess such capabilities for interfering with the even course of the judicial process that they are constitutionally banned. Harlan's opinion, upon which analysis of the constitutional holding of Estes turns, must be read as defining the scope of that holding. We conclude that Estes is not to be read as announcing a constitutional rule barring still, photographic, radio, and television coverage in all cases and under all circumstances. It does not stand as an absolute ban on state experimentation with evolving technology, which in terms of modes of mass communication was in its relative infancy in 1964 and is even now in a state of continuing change. So guess what? That's, according to Chandler, Estes does not say per se unconstitutional to televise this stuff. Since we are satisfied that Estes did not announce a constitutional rule that all photographic or broadcast coverage of criminal trials is inherently a denial of due process, we turn to consideration as a matter of first impression of the appellants suggested that we now promulgate such a per se rule. So they consider it and they deny it. An absolute constitutional ban on broadcast coverage of trials cannot be justified simply because there is a danger that in some cases, prejudicial broadcast accounts of pretrial and trial events may impair the ability of jurors to decide the issue of guilt or innocence uninfluenced by extraneous matter. The risk of juror prejudice in some cases does not justify an absolute ban on news coverage of trials by the printed media. So also the risk of such prejudice does not warrant an absolute constitutional ban on all broadcast coverage. A case attracts a high level of public attention because of its intrinsic interest to the public and the manner of reporting the event. The risk of juror prejudice is present in any publication of a trial. But the appropriate safeguard against such prejudice is the defendant's right to demonstrate that the media's coverage of the case, be it printed or broadcast, compromised the ability of the particular jury that heard the case to adjudicate fairly. The remedy always lies with the jury. It lies with the jury. So they basically, go back through like some of the reasoning of Estes, concern about the adverse psychological impact on the participants of the trial, and if it could be demonstrated that that would invariably and uniformly affect the conduct of the participants so as to impair fundamental fairness, then it would be very easy to just say, yes, we have to ban it. But they did all this study. They did all this study, and the emerging consensus is that that is simply not the case. Many of the factors, negative factors found in SD's cumbersome equipment, cables, distracting lighting, numerous cameras, technicians, those are less substantial factors today. There's also safeguards built in. Certain witnesses are going to be protected, and positive obligations on the part of the judge to protect the fundamental right of the accused to the fair trial. So, bottom line, they are rejecting this idea that there's an inherent like psychological effect from having a camera in the courtroom. It's not. It was a fear that SDs had that they like presented as though it's established, but in the subsequent years, they had a chance to evaluate that and found that no, actually the benefits outweigh the impacts. Whatever may be the mischievous potentialities of broadcast coverage for intruding upon the detached atmosphere which should always surround the judicial process, quoting Estes, at present, no one has been able to present empirical data sufficient to establish that the mere presence of the broadcast media inherently has an adverse effect on the process. You think so, but you don't know it because you don't have data to establish that. So, yeah, then they go through like the Amici and stuff like that. So to say that appellants have not demonstrated that broadcast coverage is inherently a denial of due process is not to say that they were in fact accorded all the protections of due process in their trial. So just because it's not per se doesn't mean they don't still have the opportunity to argue and show prejudice. A defendant has the right on review to show that the media's coverage of his case, printed or broadcast, compromised the ability of the jury to judge him fairly. Alternatively, a defendant might show that broadcast coverage of his particular case had an adverse impact on the trial participants, sufficient to constitute a denial of due process. But neither showing was made in this case. To demonstrate prejudice in a specific case, defendant must show something more than juror awareness that the trial is such as to attract the attention of broadcasters. Made them aware of it, but they haven't shown with any specificity that the jurors were affected in any way. And as we saw, the jurors already said, I'm aware of it. I can put that aside and not let it affect me. So he points that out as well. So there is no showing that the trial was compromised by television coverage, as was the case in Estes. Well, it kind of wasn't, was it? That was the whole point of Estes. They didn't show anything. I saw nothing as we read through Estes that showed me how the verdict was affected. I did in Rideau because you had tainted jurors, but I didn't have that in Estes. It was just literally the cameras are in there and they disturbed our sense of being above all that. Makes us maybe too accessible to the great unwashed. The proletariat get to watch us here in our in our ivory castle. So yeah, that's the gist of Chandler. So yeah, to the extent that Estes says there's a per se prejudice from televising a trial, Chandler has overruled that. Okay, they didn't specifically because they just said, yeah, Chandler never or Estes never actually said that. That's a misreading of Estes. It's complicated because it's a big plurality decision. This is why I was screaming Chandler. Estes is not good law anymore. To the extent it's good law, it's extremely limited. They limited it to the facts of that case. Chandler is now telling us what the standard is. Case by case, showing of prejudice. Last thing I'm going to take us to, which is really a big part of the bottom line for me. And we are getting a little bit late, so I am going to wrap it up pretty quick. But we're going to take a quick look at Press Enterprise. This is Press Enterprise 2, for the record, versus Superior Court. There are two Press Enterprise cases. Both of them are in the in the early 1980s, early to mid 1980s. They both involved public access issues. The first one involved access to jury selection. This one involves access to preliminary hearing. Preliminary hearing. California, same process like they follow here in Utah. You can indict, but if you don't, then charge with an information and then go through the preliminary hearing to establish probable cause, bind the defendant over or not, and then proceed to trial. So same type of process that we have here. This is one of these landmark First Amendment right of access cases. So what happened was, I'm just gonna like skim over some of the factual background instead of reading it all through in detail. But basically, this is a high-profile case, a lot of attention. The court had closed the preliminary hearing to the public. And so then the media went in and requested access to the transcript. They wanted to be able to get the transcript since, the exclusion, we've already been excluded. They've held the hearing. It's moot. So we want access to the transcript. We shouldn't be excluded from that. And that was denied. And so that is what is going up. And the justification was reasonable likelihood that release of any part, all or any part of the transcripts might prejudice the defendant's right to a fair and impartial trial. It's telling us a lot about the evidence of the case, right? Now, court originally, no First Amendment right of access. That's like subsequently, yes, there is a general First Amendment right of access to the court, but always question about the scope of it, right? We start with criminal trials. So then the question becomes, what about pretrial hearings? What about civil cases, right? And that's how it like expands and all these details get fleshed out. So this is a specific pretrial hearing context, the preliminary hearing. So they were already closed. But there's a transcript, and that's what we're going to try to get. So precisely what the California Supreme Court decided is that we conclude that the magistrate shall close the preliminary hearing upon finding a reasonable likelihood of substantial prejudice, which would impinge upon the right to a fair trial. So their code makes clear that the primary right is the right to a fair trial, and that the public's right of access must give way when there is conflict. So it is difficult to disagree in the abstract with that. Plainly, the defendant has a right to a fair trial, but as we have repeatedly recognized, one of the important means of assuring a fair trial is that the process be open to neutral observers. The right to an open trial is one shared by the accused and the public, the common concern being the assurance of fairness. Only recently, in Waller v. Georgia, for example, we considered whether the defendant's Sixth Amendment right to an open trial prevented the closure of a suppression hearing over the defendant's objection. The defendant wanted an open suppression hearing, and the court closed it anyway. We noted that the First Amendment right of access would in most instances attach to such proceedings, and that the explicit Sixth Amendment right of the accused is no less protective of a public trial than the implicit First Amendment right of the press and public. When the defendant objects to the closure of a suppression hearing, therefore the hearing must be open unless the party seeking to close the hearing advances an overriding interest that is likely to be prejudiced. So Waller dealt with a suppression hearing, which is like the key of, we're talking about evidence that may not be admitted at a trial. That's the whole point. It gets suppressed. It's not squarely on point here because it's a case where the defendant wanted it open and the court closed it anyway. But they acknowledge First Amendment, Sixth Amendment rights, relatively coextensive. Sixth Amendment right to a public trial vis-a-vis the suppression hearing, the litigation of whether we should be admitting evidence at the trial. So you got a First Amendment right that's coextensive. Here, unlike Waller, it's not the Sixth, it's the First. But you can't just label it. You can't just, be like, oh, but the other cases only talk about the right to a trial. They're not going to resolve it on that. So they establish now this test. Press Enterprise 2 is where we get the Press Enterprise test. This is the history and tradition and function, the function of transparency. And so to decide if a court proceeding has a First Amendment right of public access, this is the test. First, have the place and the process historically been open to the press and the general public? Do we have a tradition of doing it this way, openly? Or do we have a tradition of sealing this kind of thing off and doing it behind closed doors? Carries a lot of weight. Second, the court has traditionally considered whether public access plays a significant positive role in the functioning of the particular process in question. So some things would be frustrated. They say classically the grand jury depends on secrecy. But in the first Press Enterprise, we noted that openness in criminal trials, including jury selection, enhances both the basic fairness of the criminal trial and the appearance of fairness, so essential to public confidence in the system. Yeah, it definitely furthers the court process for people to be able to see it, because then we trust it. We trust it because we can verify that what is happening there is just. And if it's not, then we can exercise our right as citizens to change it. So that's the test. If that test applies, then there's a First Amendment right of access. If there's a First Amendment right of access, then it's presumed we get to see it. The presumption may be overcome only by an overriding interest based on findings that closure is essential to preserve higher values and is narrowly tailored to serve that interest. The interest is to be articulated along with findings specific enough that a reviewing court can determine whether the closure order was properly entered. So it's got to be specific. You don't just get to be like, I find there's a compelling interest. You got to spell it out why, because they're going to examine your reasoning. We've heard this many times already in this case so far. Presumption overcome by an overriding interest. So they conclude it applies to preliminary hearings. Tradition has always been open. People have been able to walk in. Grand jury is different, but preliminary hearings have been open. People can go into the courtroom and sit in them. Long ago in the celebrated trial of Aaron Burr for treason, for example, with Chief Justice Marshall sitting as trial judge, the probable cause hearing was held in the hall of the House of Delegates in Virginia, the courtroom being too small to accommodate the crush of interested citizens. So Burr had like the first big high profile, probably not, but public probable cause hearing. And it's been the nearly uniform practice around the country to the present day to have open preliminary hearings. They have therefore been accorded the favorable judgment of experience. So that's not going to be different here. Yes, Utah typically does open preliminary hearings. We are having an open preliminary hearing right now. So the issue is does it help? Does it help for us to be there? Does it play a positive role? Yeah, it generally does. It needs to be, it gives us confidence in the system. And they have some additional reasoning here that I think is intriguing and applicable. So California preliminary hearings are sufficiently like a trial to justify the same conclusion that public presence and monitoring is helpful. So in California, to bring a felon to trial, the prosecutor has a choice of securing a grand jury indictment or a finding of probable cause following a preliminary hearing. Same thing in Utah. Even when the accused has been indicted by a grand jury, however, he has an absolute right to an elaborate preliminary hearing before a neutral magistrate. I don't think we have that in Utah, but either way. The accused has the right to personally appear, be represented by counsel, cross-examine hostile witnesses, present exculpatory evidence, exclude illegally obtained evidence. We have all those things except the last one. The Utah rules very specifically say that if an argument that, evidence was illegally obtained doesn't justify keeping it out at the preliminary hearing stage, which is a little, I don't love that. Definitely don't love that. But that's the rule. They can use it for PC, but you're still going to have an issue when it comes to trial, so you better have a lot more than that. But I don't really like that, like, yeah, we'll just overlook violations of your constitutional rights for purposes of subjecting you to a jury trial. Don't love that. Anyway. It is true that unlike a criminal trial, the California preliminary hearing cannot result in the conviction of the accused, and the adjudication is before a magistrate or other judicial officer without a jury. But these features standing alone do not make public access any less essential to the proper functioning of the proceedings in the overall criminal justice process. Because of its extensive scope, the preliminary hearing is often the final and most important step in the criminal proceeding. As the California Supreme Court stated in this California case that I cited in my brief to Malice, for Malice's benefit, the preliminary hearing in many cases provides the sole occasion for public observation of the criminal justice system. Why? Because either you're not bound over and there's nothing else that happens in the case, or you get bound over and then you're like, shit, guess I'll plead, because most cases resolve by plea. So this is often the only thing, the only significant step as far as the vetting of the evidence and so forth that happens in a criminal case. Similarly, the absence of a jury, long recognized as a safeguard against overzealous prosecution, makes the importance of public access to a preliminary hearing even more significant. We're depending on the judge. People in an open society do not demand infallibility from their institutions, but it is difficult for them to accept what they are prohibited from observing. Denying the transcript of the 49-day preliminary hearing would frustrate what we have characterized as the community therapeutic value of openness. There is a reason why we have criminal trials at all. It's to vindicate our rights and our laws. Criminal acts, especially certain violent crimes, provoke public concern, outrage, and hostility. You think? When the public is aware that the law is being enforced and the criminal justice system is functioning, an outlet is provided for these understandable reactions and emotions. And to the contrary, when you don't have confidence in it, you got a lot of public unrest, public anger, hostility. The value of openness lies in the fact that people not actually attending trials can have confidence that standards of fairness are being observed. The sure knowledge that anyone is free to attend gives assurance that established procedures are being followed and that deviations will become known. Openness thus enhances both the basic fairness of the criminal trial and the appearance of fairness, so essential to public confidence in the system. So they conclude First Amendment right of access applies. We're not quite done yet. We're not quite done yet because we've acknowledged the right applies, but the right can be overcome. And now we're talking about a preliminary hearing butts up against the right to a fair trial. Preliminary hearing involves the presentation of evidence. You see it before trial, you might get the idea the person's guilty. Isn't that the argument we've been hearing? Press Enterprise addresses this. So they're not without concern. There's this previous case, Gannett, that was subsequently overruled, but they are kind of like re-accepting some of the early considerations. Publicity concerning pretrial suppression hearings poses special risks of unfairness because the whole purpose of such hearings is to screen out unreliable or illegally obtained evidence and ensure that this evidence does not become known to the jury. Publicity concerning the proceedings at a pretrial hearing, however, could influence public opinion against a defendant and inform potential jurors of inculpatory information wholly inadmissible at trial. This is the defense's argument, isn't it? This is what Mr. Novak has been arguing. Gannett involved a case where they closed the suppression hearing to the public. They said that was okay because of this issue. So it would be okay to close the suppression hearing. Gannett has since been reversed by Richmond newspapers and subsequent cases. You cannot per se close any pretrial proceeding. You need to now apply this press enterprise test to decide if there's a First Amendment right of access, and then go through the prejudice analysis. But here's what they say about it, right? They acknowledge this is a concern, but the risk of prejudice does not automatically justify refusing public access to hearings on every motion to suppress. Through voir dire, cumbersome as it is in some circumstances, a court can identify those jurors whose prior knowledge of the case would disable them from rendering an impartial verdict. And even if closure were justified for the hearings on a motion to suppress, closure of an entire 41-day proceeding would rarely be warranted. The First Amendment right of access cannot be overcome by the conclusory assertion that publicity might deprive the defendant of that right, and any limitation must be narrowly tailored to serve that interest. That's press enterprise. They're well aware. They're well aware of the situation. And they've said, like the judge has said many, many times, and has been really good at applying so far, the remedy is looking to the jury. So I wanted to share all of this with you guys because this is near and dear to me, this topic. I continue to explore it in all of the different jurisdictions and try to, get to know more about the variations and where the nuances are and kind of what's still up for maybe future consideration by the Supreme Court because there's circuit splits and things like that. I've looked a lot at this issue, and I think they just got it flat out wrong today. Judge Graff has been so good so far, but I think he got it flat out wrong today. And I think it really goes back to this Estes thing. That I'm not going to say Mr. Novak is unethical in his presentation of it, but I don't think his characterization of it is accurate. It's not the holding. To the extent it was the holding, Chandler said, no, it isn't. You got to take this stuff case by case. And then you have the timing, the fact that Estes is long before we have all of these considerations about public access anyway, and how you mitigate that. There's nothing special about TV cameras. That was the whole point of Estes. There's something special about TV cameras. It's not about publicity, period, and the prejudice that results. Estes is still going to let newspapers in and report anything they want and all the pretrial publicity, and so is literally the cameras. And the First Amendment cases are recognizing, no, it's broader than that. It has to do with just publicity, period. It doesn't matter what the source of it is. So I continue to hold out some hope that this invitation for briefing by the court is going to be fruitful, that some of these cases are going to be brought to his attention. I have no doubt that if the media files a brief, and I so much hope they do, they know these cases. They've cited these all a billion times. There's like nothing groundbreaking about anything I've presented here. I mean, obviously, the most recent case we looked at was 1986. So there is still an opportunity for a course reversal here. And I very much hope that happens. And I hope that maybe Judge Graff has taken the opportunity this evening to sit down and really dig into Estes and maybe shepherdize it. Maybe notice Chandler had a few things to say about it. Because I know Mr. Novak knows about Chandler too, but he didn't bring that up. And this, guys, is kind of summing up the problem with sandbagging and why courts shouldn't tolerate it. You got to bring things up in a timely fashion instead of trying to spitball important constitutional issues and complex opinions and subsequent legal history. This is why you brief things ahead of time, so that you get it right and everybody is accurate, because they're not just running with it on the fly. Yeah, Mr. Novak has lost some of his shine for me. All of you guys that I won't yell at you anymore, I guess, for calling him Slovak. Lost some of his shine for me with this one. I don't mind people, you gotta argue your position, and no doubt he sincerely thinks that he's trying to do the best thing for Tyler Robinson. No doubt he thinks that. But I don't respect doing that in this not forthcoming kind of way. Can't respect that. And I still hold out hope for Judge Graff, because I think basically he just got bamboozled. He allowed himself to be sandbagged and got bamboozled by a representation of what the law is that isn't accurate, that he didn't have time to sit up on the bench and figure out for himself. So I still have hope that the broader legal context here is brought to his attention, that he will in fact do the right thing and realize he's actually been doing the right thing the whole time, all along, by pointing out the issue here is about selecting a jury. That's the issue that comes up with publicity. And so, yeah, you got lots of tools available to you to weed out us hardcores, which is absolutely not a majority of the population that are over here like watching every detail of the preliminary hearing. I still have faith that Judge Graff will do the right thing if what the right thing is brought to his attention. So please, media, please, putting this out there. Maybe Erica Kirk's lawyer, Mr. Nyman, seemed to matter a lot to him. Maybe put this out there. Chandler, guys. Chandler's real important. Chandler's real important. Because Chandler's the one that says, Estes doesn't say what Mr. Novak has told you it said. So that's my takeaway for today, and we'll see what tomorrow brings. I see we got a few comments from you guys, and we'll get through those and then get ourselves a good night's sleep to start it all over again tomorrow. Kyle Wilbur, 4318. This might be the first trial I followed, but the judge seems very fair. I still love Judge Graff. I really do. I really do. I think he got bamboozled because he's trying so hard to be fair. He's trying so hard to be fair to the defense that I hope he learns that that can be taken advantage of. And I think that's what happened today. His fairness in entertaining this untimely thing that should have been brought up a long time ago in writing and briefed and wasn't. His fairness got taken advantage of and he got bamboozled as a result. And if I'm the judge and I'm coming to that realization, I'm pissed. I'm not pleased with what happened and with where we are right now. And my trust has been damaged in the representations of the attorney. I guess it's official. Mr. Burt's my favorite now. Mr. Burt, don't let me down. He's been really good so far. Don't let me down. Trigger Smart, can the prosecution appeal the judge's decision to redact portions of the Twigs 1102 video or audio? Theoretically, yes. It's always a theoretically yes, you can appeal an adverse decision, but for practical purposes, all kinds of them, it's not going to do anything. Number one, we're talking about interlocutory appeal. Publication, okay? Remember, we got this difference between is it being admitted as evidence and is it being shown to the world? The judge hasn't said any of this is not being admitted as evidence. So it's not really prejudicial to the prosecution in terms of their ability to establish probable cause. All of this is about is the public's ability to see it. So how is the prosecution prejudiced by that? And publication of an exhibit, that's discretionary with the court, whether he's going to allow it to be shown in open court or not. We don't have a constitutional right to publication of exhibits. So, interlocutory review of discretionary decisions doesn't happen. It doesn't happen. They're too deferential, and you get interlocutory review pretty much only when the law is so clearly on your side that there's like no question the judge messed up and it needs to be fixed. The other problem is it can't happen in time before we get done with the preliminary hearing, and it will be moot. It'll be moot. We've already gone through the preliminary hearing. It's already not been published. So there's not really any way to run back the clock, at that point. So, I mean, in theory, yes, but in practical terms, no. No, not really. They're not going to meet the standard. It's going to be moot. It's not really prejudicial to them anyway. Base Player 2011 IFY, since we are talking about televising trials, do you think we will ever see televised federal trials, or are the court sketch artists safe? So there is actually a pilot program going on in a few limited federal courts right now, similar to what they were talking about that Florida did back in 1970s. Federal courts finally getting around to doing it themselves 50 years later. So they are starting to do that and explore the possibility. It's not widespread now, but they are putting their toes in the water. And so depending on how that goes, yeah, it's possible that we could see it. I hope we do. I really hope we do. Just feel like I feel like I don't really know how to describe it. I don't have the right words. Like I need to think about it, how to formulate my idea, but it's like a class thing, I feel like. They just feel like it's diminishes them. They have themselves like so high up on this pedestal as judges in the court and everything that like TV is just so common, so bourgeois. Called it proletariat before, now it's bourgeois. It doesn't really matter. The judge is the ruling class, and all of us lessers converting it into our lesser, medium of entertainment and education. I just feel like that's a lot of it. Certainly what I got out of Estes, dignity and decorum of the court, inherently. So yeah, it's possible. I hope that I haven't checked in on that project in a while. Maybe I will do that. See how that's going. But it is possible. D74715, j'adore votre analyse. Continuez comme ça, Madame Burkhardt. Merci beaucoup. Merci beaucoup. Je suis... Oh, mon Dieu. J'ai oublié beaucoup de mon français. Il y a très longtemps, pendant que j'ai habité en Belgique. Mais anyway, thank you very much for your nice comment. I do appreciate that. Just a little bit of French. Kyle Wilbur 4318. Is there a worry about Mormons being on the jury? Not for me. Not for me. I mean, the West as a whole, we got a lot of Mormons around here. It's just not really unusual. I don't have a problem with Mormons. I actually did I did do some research, like really early on in this case, some preliminary research. I was kind of curious, like, is there an official Mormon position on the death penalty? I was wondering about that. Does the church, does the LDS church have an official penalty position on the death penalty? They don't, and it actually appears to be a subject of quite a bit of disagreement. Roughly 50-50 from what I was able to see. About half of the church thinks, yeah, it's okay. About half of the church is not in favor of the death penalty. And so that's going to tend to be favorable to criminal defendants. Just in general, the more you believe in the death penalty, the more you are likely to convict people. Another thing that's been studied. So I don't particularly worry about that. I think that's what Mr. Novak was getting at yesterday with the whole bringing in the evidence of the Christian beliefs and so forth runs the risk of positioning the parties on like the teams, team Christian, team anti-Christian, and then the people who on the jury who identify themselves as Christians are going to naturally resonate with one of the teams more than the other. But I'm not real concerned about that. I'm really not. As me personally, your mileage may vary. If anybody's got any ideas about, why we should be worried about Mormons on the jury, if we should, but in a way that's not going to get us into YouTube community standards problems, please. Let me know. But there's nothing particular about Mormons that I think is inherently problematic as jurors. D74715 per se dicta res ipsa MDR c'est du corneau pour avocat ou au moins du joie. You're beyond my many years old recollection of my French vocabulary at this point. What I've lost is the words. That's the thing that I really noticed. I lived in Belgium when I was a teenager, from roughly 12 to 15, 12 to 14. So I learned French, and you had to use it every day and stuff like that, and I got pretty good at it. But it's been quite a few years, and I went back and visited. How old was I? 20, I guess, when I was 20, and I haven't been back since. But even already by 20, I had already forgotten a lot. And what I found was, like, it was really remarkable going back and just being in the environment again. Came back very quickly. But not being exposed to it all the time, I still remember like how the language is structured and stuff like that, how to put it together, but I remember like all the grammar basically, but the words, the vocabulary is just gone. I don't remember how to say anything. So gotta constantly look at the dictionary for my words. Thank you for your French contribution. I do appreciate it. Lex Forge and Andrea, you need to file a friend of the court brief by 8 a.m. tomorrow on behalf of the media. Just use AI to summarize your arguments here, LOL. I don't really believe in friend of the court briefs at trial. I mean, I appreciate that this is specifically a circumstance where, the media gets a right to have a say, and they do that as proxies for the public. But what if I'm not satisfied with the proxy? I'm still intended to be, probably could do it, but I'm really not inclined to do that. I don't want to insert myself, Didn't particularly want to do that in Malice's case either, but she forced my hand, taking a stupid position that I wouldn't be able to access the trial exhibits. So my goal here is to simply put this out there in the universe, and maybe people are watching for whom this information will be useful. Maybe just the good vibes and the good hopes. We're putting the manifesting, if you will, manifesting that the media is going to file a good brief, and that all of these things that we talked about this evening, we will see cited in that memorandum. I'll be checking Exchange bright and early in the morning. D74 715. Whoever Andrew is, you better file an amicus brief. Yeah, I understood. I understood. I'm actually named after my uncle Andrew. It happens. I get it. Debbie W8599. Andrea, another lawyer covering this case said Utah doesn't have grand juries. Do they or don't they? So they do, but they're very limited in their use. They have this process that like, it isn't like most states where the prosecutor just convenes a grand jury, or sometimes you even just have like regular grand juries going on all the time. I forget the details of this process, but like it has to kind of be approved by the judge or something to go to a grand jury. There's like a limitation like that. And so the practical result of that has been it's hard to get a grand jury. And so my understanding is that like in practice, it's not even really that common to try anymore. But it is technically available. Just subject to a lot of those limitations. Kristen 278, can you imagine if Novak let in Candace Owens' evidence into the defense? That's the wrong attorney to offer this to Candace. I don't think he has any interest in going down that rabbit hole. You know, disingenuity has its limits. But ultimately, I mean, again, he wants to do what's in the best interest of his client. I'm not going to hold that against him. I don't really respect this, but I'm not going to like, it's not, you know, I'm not really a grudge holder. I'm not like, you know, you're unforgivable and I'm going to wipe you away. Like it would take a lot to get me to that point. Like I'm just going to write you off. You're worthless. Which is why I am not a fan of the death penalty myself. It's just my personal approach to stuff. I'm a redemption person. I'm very much in favor of redemption and everybody having the opportunity every day to be better. And that to me is just a very important principle to live by. So I think the bottom line is that the reason we are not hearing Candace Owens' evidence from the defense is because it would not be in Tyler Robinson's interests in their judgment for that evidence to be associated with him, for them to take that on. If it was, they would. But they don't think it is. And they have pretty explicitly made a point of distancing themselves from it and mildly condemning it. So I think they've made their position on that pretty clear. Little after 11 o'clock, guys. Not too bad. Not too bad. Only a slightly under 4-hour live stream tonight. Guys, we did it. We did it. But I am going to go ahead and wrap it up now so that we can get some sleep. Be back at it 7:45 Pacific time tomorrow, bright and early, to get us going for a full day and see where it goes. I have a feeling we might start with where we ended today. So we want to be bright-eyed and bushy-tailed. We want to be chipper for it. So guys, thank you for joining me. Hope you appreciated this little meandering through some of the fundamental case law and right of access and cameras in courtrooms and things like that. Important and timely. So it's all consonant with our interest in watching the trial and seeing if justice is being done. Anyway, so I enjoyed it. I hope you did. Thank you all. Thank you, mods. As always, the mods are putting in some long hours here, especially, of course, the one and only Jeff Burkhart. Appreciate all the time he is putting in. I see Hella's here. Excited utterance. Thank you. Thank you, guys. Really do appreciate everything that you've been doing. So with that, we will be back at it tomorrow morning, guys. get some sleep, and I'll see you then.